this. Null pros in the case, was that the speedy?
Yes.
That was so fast. I guess that's what's supposed to happen with speedies. Okay. All right, I think we are where we're supposed to be. Ms. Nelson, good morning. Who's on from Decatur County CI? Maybe we can try to, that's position one, Keither Harris?
Yes.
Okay.
Good morning.
Good morning. All right, well, it's going to come first anyway. So we have a plea and arraignment calendar that's semi-multi-purpose. I think we've got a probation revocation and a couple other things on that calendar. And then Mr. Aurora, we've got sentencing for Mr. LaChapelle. I'm going to try to get through our plea and arraignment calendar first and then pivot to that. All right. I don't see Mr. Bridges. He's planning on being here.
Reached out to him, Judge. I have not yet heard back, but I would assume.
Okay, we're good because we'll get through this stuff first, but I just want to make sure it's on his radar.
It is, Judge. We're holding for his report. He's in another courtroom.
Okay, great. That's what happens when you don't start at 9. Position one is Keither Harris, who is right there. Mr. Harris, can you hear us? Yeah, is there a way to unmute there? And there we go.
Yes, sir. I can hear.
Great. Hey, Mr. Harris, I'm Judge McBurney. Your case has been assigned to my division, and you are on for plea and arraignment. Is this a case that Ms. Wood, you have?
Yes, Judge. And I need to speak with him to see if it can resolve today. Do you want me to go get on Zoom?
Let's go through a few more positions and let me tell Mr. Harris what's going to happen. Mr. Harris, your lawyer is here in court. Whoops. I'm going to add one screen. Can you kind of lean in and wave? There we go. That's Ms. Wood. She's your lawyer, and in a few minutes, she's going to go into a room near here and join the Zoom call individually. I'm going to move you and Ms. Wood into a breakout room so you can speak privately. So she can tell you more about her situation. You can tell her about yours. And it may be, given the nature of these charges, this is a case that can be resolved today. Tell me why you are at Decatur County CI.
For a violation of probation, but the stuff for what I'm here for now. All the charges, what I'm in here for now.
Okay. How long did you get revoked?
2 years.
Okay. And how much do you have left of that revocation?
A whole year.
Okay. All right. That's probably why Ms. Wood wants to talk to you about this. So I'm going to call a few more positions on this calendar and then I'm going to connect you two. Okay. So if you'll sit tight in a little bit, you guys will have a private conversation.
Okay.
Thanks. All right. Mohammed Doumbouya. Good morning. Have you filed an entry of appearance?
Yes.
Great. Let me pull the case up and we can figure out. Thank you, Mr. Doumbouya, for doing what you said.
For him, she doesn't care about doing something.
Mute Mr. Jones there. Mr. Jones, can you mute, please? All right. All right, Mr. Lane?
Yeah.
Great, you filed an entry. Today is plea and arraignment. Is Mr. Doumbouya waiving arraignment or does he want to be formally arraigned?
We were in formal arraignment.
Okay, there's a waiver form that I'll ask you to fill out on the shelf right there by Ms. Simpson. You can do that in a minute. And when you're done with that, you may want to talk with Ms. Smith, the prosecutor on the case, but otherwise you and Mr. Dumbuya will be free to go. The way the cases flow in this division is that I'll file a scheduling order after that waiver of arraignment hits the docket. That gives the state a deadline to get you discovery. Your motions deadline is not until after that. So don't worry about, do I have 10 days to file motions? You have more than 10 days because you need discovery first to know, is there something to suppress or whatever. So Ms. Smith and her team will be working on getting you discovery by the deadline that'll be in that order. You'll have a motions deadline. If there are no motions that you file, then we'll all be back here for a final plea a few months down the road. If between now and then you and your client work the case out and he wants to resolve it, let Ms. Nelson, my litigation manager, know, and we'll get you into court. We don't need to wait until that deadline. That's just the last time we can do it. Okay? Mr. Dumbuya, let me confirm a few things with you. I have a Camp Creek Parkway address. That's still good? Okay. And your bond. You're supposed to stay away from an address in College Park and a gentleman with the last name of Larker. You understand those conditions? Okay, are those things that have been easy enough for you to do? He was a tenant of mine. All right, so he's not around. Good, okay. Do you have any questions about what's going on? Okay. When Mr. Lane has filled out that waiver of arraignment form, then the two of you are good to go. Thank you. You're welcome. Thanks for being here. Ms. Smith, anything from the state on position 2?
No, you're not.
Okay. Kerwin McCallman? Good morning, sir. You were going to get a lawyer as well. Today is how are we doing with the lawyer day?
I'm actually feeling, if I have some what I need to do so, I just ask for continuous to deal with people's staff.
Who's that lawyer?
Mr. Benson,
What, spell the last name.
REMSON.
All right. Are we good?
Let me get a chance. Can we do it on this position?
Yeah, so it is that. Okay, yeah.
Like literally.
All right, we'll do that next. Can you spell the name again? I'm trying to find this person.
Oh, yeah. REMSON.
REMSON. Oh, Rock Remsen. There it is. All right. It's a great lawyer name. And you and Mr. Remsen have had initial discussions?
I just need to, something will get what I need, the rest of what I need.
Okay. What is a reasonable amount of time to give you to get the rest of what you need? Okay, so if we bring you and Mr. Remsen back in mid-March, so a little more than a month, does that work? That'll probably be the last reset. If you haven't managed to retain Mr. Remsen by then, we need to move the case along, so we'll have to figure out what we're gonna do, okay? All right, any questions about that? All right, but you feel like the discussions with Mr. Remsen have been serious, it's just a question of sorting out the financial situation? Okay, all right. Ms. Williams isn't here. Anything from the state about the McCallman case?
No, you're not.
Okay, all right. Then I want to make sure we've got a good address for you. Did you get something in the mail telling you to be here? Forest Grove, Ohio? You came all the way from Ohio? Huh. All right, thank you. May want to reach out to my office. If you haven't hired Mr. Remsen, by whatever the next date is, so that you don't come all the way here. But hopefully you and he fill out the paperwork you need to so we can get this moving forward. But that Forest Grove Avenue in Ohio, that's still you. Okay. All right. Thanks for being here. Mr. Lane, I think we're all set. Appreciate it. We are going to jump ahead to Ms. McClarity. Before we bring her out, you had wanted to argue bond as well. Are we going to do that now? Okay. Who has position 7 and is co-defendant 7 and 8?
That is Ms. Williams, and I've literally been texting, once I recognize McClarity was here, trying to get any info I can, because I know that she is in Judge Baxter. The case, I believe, may be continued, but if not, Ms. Williams will be going out to trial.
In a trial, right. Judge Baxter's trying to move some cases. Okay.
So I'm trying to get some info on the case. So if your honor could just give me a moment.
Okay. Okay. And Ms. Williams did let Ms. Nelson know she was stuck. So I'm just seeing this now, and I opened up Teams. Okay. So, Ms. Wood, we're going to wait maybe one more defendant to see if we can get any info.
Okay.
All right, position 4 is Trevelyan Bradford in custody.
He's mine, Judge. I think I'm probably just waiving arraignment today, but I do need to speak with him briefly.
Okay, in custody in here, or he's one of the Cobb guys? Okay, all right, we will come back to him. How about Mr. Barber? He is in custody. He's been in custody for a long time. He's here as well, and that's a Rios matter.
Yes, I filed a waiver. I'm holding off on doing a bond hearing until, because once we look into it.
Okay.
So we'll bring him back after CUP is accepted. Maybe we can just bring him out real quickly, just let him know that.
Sure, if we can bring Mr. Barber to the door, please.
Yeah.
He's on probation?
Can they, if they have another warrant, they still go.
We have to clear up the warrant. What's the warrant for? Is the warrant for probation?
It is.
But what we might do is revoke him into drug court. Oh, it's another jurisdiction. But we could get him admitted and then he would go to that jurisdiction. Okay, I don't know about all the time, but we've done that before. Yes. Okay, well, 3 times, okay. Mr. Barber, hey, I'm Judge McBurney. Nice to meet you. Ms. Rios was telling me a little bit about your situation. We had you on the calendar today for 2 things. One, it's your arraignment date, but Ms. Rios has already waived arraignment for you, meaning she's entered a plea of not guilty and is moving the case along. Then you were also on to have a conversation about bond, but Ms. Rios said we should table that for now for 2 reasons. One, she explained that she's going to be exploring your eligibility for drug court. She's going to do that, so we'll probably have the intake team come interview you. The second reason is you got a warrant, it's a probation warrant from what jurisdiction? Henry County. So even if I were to set a bond, you'd need to go to Henry to deal with that. So I think what we're going to do, so you know, but you and Ms. Rios can talk about it more, is have drug court come talk to you to see if that is an option. And if the answer is yes, then Ms. Rios will talk with the prosecutor, Ms. Smith, to see is this a case that could resolve until you go into drug court. And if the answer is yes all around, you want it, drug court says yes, and the state is amenable, then we'll get you to Henry to work out whatever that is and hope, and we'll explain to Henry County, he's pled here, he's gonna get into drug court, so if you could revoke him into drug court, he's been in for a long time, they might be willing to say, time served, let's get him treatment in drug court. I can't promise you that. Henry does what Henry does, but that would probably be your roadmap. If drug court says yes, then we would sort that out and then get you to Henry County. Okay? That was a lot. Did you follow all that? All right, any questions? You'll talk with Ms. Rios. Okay, she'll talk with you soon. Thank you, sir. Luis Ramirez Perez.
He's my
It
judge.
doesn't.
I think we have an interpreter here. For whom do we have the interpreter? This class. Well, let's knock that one out then. Okay.
Oh, yes, there's two.
You have two.
Yes.
Okay. Jose Lopez is the other. Okay. And you've got that also. All right. Have you had a chance to speak with Mr. Ramirez Perez? Or do you need a minute with the interpreter to do that?
I've seen him at the jail. I do need to speak with Mr. Lopez with the interpreter back, so we can do both of them.
Okay.
Briefly.
All right, let's table that. We'll get you back there in a second. Then we get to Ms. McClarity. Any update from Ms. William? Oh, we know where she is. She's stuck in 8A.
Yes, Judge, I am communicating with her at this moment. I am gonna try and see what I can do for the McClarity bond motion.
Okay.
But I don't see where we have necessarily been able to get in touch with, the custodian.
Okay.
And just give me a moment.
Okay, no, I'm just checking in because we got to that position.
And she is, communicating with me, Judge, but I think that is the issue, that we weren't able to get in touch with.
With the custodian. Okay. There's the added complication of Ms. McClarity and having a brand new infant, which is another reason to make sure we talk about bond today. Okay, Montavis Walker is the co-defendant. He's in custody. That would not be you, Ms. Wood. Do we have, let's look. Yes, Ms. Cabrera filed an entry and waived arraignment. So if you want to bring Mr. Walker to the door, please. Let him know that. Ms. Wood, have you waived arraignment for Ms. McClarity, or that would be part of what we would do today? Either way.
I've actually been speaking with Ms. Williams. I was trying to see what we could do. I was hoping we could handle this before she had the baby, but we didn't.
Okay.
We didn't.
Mr. Walker, hey, I'm Judge McBurney.
How you doing?
I'm doing okay. Your case has been assigned to my division, and you have had a lawyer appointed to represent you. Ms. Cabrera is her name. She is stuck in another courtroom right now, but she filed a waiver of arraignment on your behalf, which is entering a plea of not guilty and starting the process so she can get the discovery in this case, whatever that is, police reports, statements or whatnot, so she can meet with you, talk about what the state's evidence is and isn't, and we'll go from there. I just wanted you to know why you got brought over today. We didn't get that waiver of arraignment until too late, so we ended up bringing you over, even though that had happened. But I wanted you to know you've got a lawyer. She's already working on your behalf, and she will figure out a time soon to come see you, okay?
Social work, I've been trying to talk, I'm not doing my social work being for a long time.
So when you say social worker, tell me what are the kinds of things you'd want to talk about?
And the program,
before getting into a program. So what you'll want to do is talk with Ms. Cabrera. And then she would coordinate getting a social worker. I don't assign them. It goes through your lawyer. So Ms. Cabrera will be out soon to see you, and that's a discussion you guys should have so she can start thinking about what kind of programs might make sense. And she'll be talking with the prosecutor to see if the prosecution thinks a program makes sense or not. Okay? Any other questions? Okay, nice meeting you. Christian Rakestraw is a revocation. Is that something you're handling, Ms. Rios?
To handle that.
Okay, have you already?
Hi, Attorney Courtney Shelton for Mr. Rickshaw.
Uh-oh, do you guys need to arm wrestle?
Yeah, no.
She had it. I'm glad he's overrepresented. That's rare. We don't get that a lot. Can you tell me your last name again? Shelton?
Shelton, SHELTON, and first name is Courtney, Your Honor.
Okay. Ms. Shelton, thank you for being here. Did you represent Mr. Rakestraw before, or you've been brought in? Great.
I've been hired, well, our firm has been hired.
Okay.
To handle this matter. I have not spoken to Mr. Rickshaw, and I don't believe that his probation officer is here. She is from the county with Officer Brown.
Okay, what I have is a warrant that was signed by Ms. Gresham, but that doesn't mean that was the person supervising him. The allegations in the warrant are new charges, and he had done very little of his community service. We don't typically have the supervising probation officer in court when the primary allegation is new charges. That person doesn't know much more about it than you or I know about it. We have Ms. Simpson from the Department of Community Supervision, who may well have been in touch with Ms. Browning or Ms. Gresham, so you could speak with her. And Ms. Smith, is this something you're handling?
Yes.
So Ms. Smith is the prosecutor on the case, so you all should talk. Mr. Rakestraw is here, so you can meet with him. And we can decide, is this something that he's going to stipulate to and we work it out today, or is he contesting it, in which case we will set it down for a full-blown evidentiary hearing? So the state will know to get a witness or witnesses here. We'll get it on your schedule and handle it that way. Does that work?
Yes, sir, that works. I would like to speak to the state about him possibly getting released today.
Okay.
So
Great.
at that time.
All right. We're going to be taking a break shortly, and Ms. Smith and Ms. Simpson are the two folks you'll want to talk to. All right. Thanks. Cameron Wright.
This is Ms. Gordon's case, Judge. And one of the speakers now.
Oh, is this one where we're just sort of checking in?
I believe so, and she is in front of Judge Cross, and she will be here as soon as she's released.
We'll hold that. And then we've got Jose Lopez, but you and the interpreter are going to speak with him. We have Mr. Johnson again. Is Mr. Johnson here, or is he online?
He's present online, Judge Bar Jones, this for Alburn Johnson.
Yep. Hey, Mr. Jones, how you doing?
I'm doing well, Your Honor. How are you, sir?
I'm all right. Is your client with you, or he? Oh, no, I see. He's right here.
No, yeah, he's on there somewhere.
Okay, there he is. Great. I'm glad he appeared virtually rather than in person. I don't have a whole lot to update you all on. Do you have any updates for me, other than that I need to tackle a couple motions?
No, not at this time, Judge. Just that motions hearing calendar date. That's all we need.
Okay. Ms. Nix, is this your case, or is this Ms. Williams's case?
Certified, I'll be there.
It's Ms. Williams. Okay. The prosecutor is stuck in another courtroom. So tell me, Mr. Jones, which of the motions you think we need to have a hearing on? I know you've got several.
Yeah, the Bobo hearing, we need to bring in those psychiatrists or psychologists, whoever treated the alleged victim, and have
Okay.
a hearing.
Okay. All right. Well, we will line that up. And your client will be free to appear virtually for that if he wants. He's welcome to be here in person, but that's not the kind of thing where he'd need to testify. So I'll let you guys work that out. I just want to, since this is dragged out on my watch and not yours or his, minimize the times he has to come down here.
Thank you, Judge. Much appreciated.
Okay, well, I will circle back with Ms. Williams, the prosecutor who's on the case now, and we'll figure out a date and time for that hearing.
Thank you. Are my client and myself excused, Judge? I don't have.
You
any other
are.
matters.
Thank you. Thank you both for being here.
All right. Have a great one.
You too.
Never showed up in any of my.
Mr. Johnson, you're free to go. Cody McGlone. Ms. Rios, this was a bench warrant, and now Mr. McGlone is here.
Yes. Have a hearing on today's side.
Okay, that we're just working through that. Okay. All right, and Ms. Willingham, that's gonna be you?
Well, position 13 is me, and Judge, he needs to be arraigned on position 14, which is gonna be Ms. Nix.
Oh, look at that, 2 cases.
And Judge, a motion to recall a bench warrant was filed on position 14, but a bench warrant was never actually issued on position 14. He's just in judicial hold because he failed to appear on position 13.
13,
Oh, okay.
So all we need to do on position 14 is just deal with arraignment.
got it. Okay,
File a waiver on both.
and he's here?
Yeah, he's now.
He's arrived, he's downstairs, all right? And then Quadine Hardison. Hey, sir, how are you? All right, I think we had, is this the case where Mr. Hardison was saying, I don't mean to put it on the wrong person, I was volunteering with this food services thing, and then you did a whole lot of investigation, and I had no idea who the supervisor is, and we don't know who Mr. Hardison is. So where are we now?
I mean, what's at stake? I'm assuming, I think at one point the state was asking for additional community service hours.
Why don't you guys talk,
Okay.
and we'll make a plan. All right, that's it for the calendar. Anyone here who didn't hear their case called? Then what I'd ask is, let's use the interpreter and see what we can do there. And then hopefully we'll get a little more information from Ms. Williams about Ms. McClarity and what we can do there. And then you have a busy morning. Maybe you could hop on with Mr. Harris in Decatur County, and we could handle some other stuff while you're doing that. Okay? I'll be right here. Mr. Aurora, do you have everyone you need for your sentencing?
Yes, including.
Pardon me?
Including our expert. So. But this is available, sort of.
Okay. Oh, we don't have Mr. Bridges, so got that issue.
When she goes to the background, we can find out what the verdict he resolved it, but I think we should be able to get an answer to respond today.
Okay, this is for Ms. McClarity? Okay. And we can certainly say no contact with, et cetera. Okay. So she has a bond, she just can't make the current bond. Ms. McClarity?
Yes, sir.
Okay.
I don't know anything about the new charge. Right, it was.
Yes.
I'm gonna.
Also,
Thank you so much.
Yes.
Absolutely. Oh, yes, sir. This is it. Usually the surgery just that way. I'm not sure. Okay, no, you're fine, absolutely. I'm sure it will work, so you're good, but that's what that was right there. I think it's going to stipulate two instructions. So now we have a record. This was the public school case, yeah. We accept this case to go down. That's. So we were going to charge with. So I'm not sure. If not,
Ms. Simpson?
Yes, Judge.
There you are. I was like, she's gone. What changed with Mr. Coffey, his updated petitions?
That's the question, that's what I'm trying to figure out. I'm sorry, we added. It looks like, more so, it looks like details.
Okay,
From what I can tell, it didn't change anything.
and he's been terminated from drug court.
Yes.
So this is all,
Yeah, we already terminated him.
okay,
But he's been to court on his charge that he picked up when he got into it. That's been on his stand.
okay,
And I think that's what she included, that he had been in court on those charges.
okay. Okay, so it's just, he happens to have 4 cases. It's the same change on all 4. Is he on for Wednesday?
Yeah. I'm assuming so, because I saw, Ms. Hankins, requested for Mr. Culver to be added back on.
Oh, okay. Good morning, Mr. Bridges. How are you?
Good morning, Your Honor. Apologize for my delay. I had to Port Richardson first.
No, you did. You told Ms. Nelson, she told me you were stuck. I think Mr. Aurora has everyone he needs. There are a few matters I need to take care of first because we have an interpreter here and we've got someone online from a Department of Corrections facility, and then we can pivot to La Chapelle.
Sounds good, Your Honor.
Are you good this morning, or do you have another destination?
Not till 1:30, Your Honor.
All right, we'll be done before then. Me too. Is this the guy who spit food on? Okay. Yuck.
Yes.
Yeah, they probably be sending my lawyer on him.
Yeah, I don't mean to interrupt you. Do we have a copy of the indictment for, the Chappelle?
I can print one out if you need it.
Yes, you are. We need a copy.
Okay. You need it for what?
But please. Actually, I have a copy of this.
Okay, what I do is ask the lawyers and the defendant if they're all right having someone on my staff electronically sign it. So unless that gives heartburn to Mr. Aurora, that's the SOP here and in a couple other courtrooms. Okay, so we're good to go.
Thank you.
You bet.
That's
Ms. Wood, are we able to go forward with any of your cases now? Either Lopez and go forward means arraign, not arraign, whatever, or do you need more time?
I guess we need Deputy Gordon.
Okay, we'll get him out here in a sec. I'm just wondering, you also need to connect with Mr. Harris. Wondering if you want to do that or?
That I'm hoping is a plea.
Yep.
I didn't know, whatever the court prefers, I'm happy to speak with him. I didn't know if I should maybe tackle people that are here before him or.
Well, why don't you, let's do this. If we are able to figure out a plan for Ramirez Perez and Lopez and McClarity, we could do those three. And then I could pivot to La Chapelle and take that plea while you're talking with Harris and we're working through a few other things. Does that work?
That's perfect.
Okay,
Thank you.
all right. So when Deputy Gordon resurfaces, I think he's getting the Cobb gentleman who arrived. Are you ready on any of those three?
If we could, I'm ready on McClarity, but I'm not sure.
We just lost another prosecutor.
We can do that one, and then I just need to speak, Mr. Lopez is one of the Cobb inmates.
Oh, so you all haven't had a chance to speak with him yet. Okay.
But it should be very brief.
Okay, but you did speak with Ramirez Perez.
Yeah, so he knows what's happening.
And is this just a waiver of arraignment?
Yes, both of them. Is Lopez on for, both of them are gonna be waivers. I can't remember if Lopez is also on.
Lopez, I'll look, but he had a FTA. He may have done waiver a long time ago.
I can't remember, but
Let me look.
he's got a hold from Forsyth, so I'm not requesting the bench warrant be lifted.
Okay.
So it should be pretty quick once we get back out here.
Okay.
Good. I forgot.
Just Matthew thrown in something.
Sure.
Verify.
What do you have?
Just a special one set aside.
Oh, for McGlone?
Yes.
Okay.
Should be fine. Thank you. I think, yeah, we have a good. Yeah, it's like, that's a Okay. Because I know my client was in contact. Okay. Yeah, so I worried about that. Yeah, I just there was a
So Lopez hasn't been arraigned, so we'll want to do that.
Perfect. Thank you.
Or you can waive it, but I can explain to him what's happening.
Deputy clients. I love someone, like I said, it's good.
So Deputy Gordon, if Mr. Lopez is up now, we'll have lawyer and translator meet with him, and then he'll come out. The other gentleman using interpreter will come out, and we'll do McClarity.
Okay.
And we can do it in whatever order Ms. Wood says. Ms. Rios, it does not look like we'll get to Denike on the Emerson calendar.
Okay,
'Cause-
trying to murder.
I don't know what the case is that's going this week. If Ms. Charles, is it likely a murder? If Ms. Charles, it's King, it's from, I think, Carnesale. It's a murder. It's short. They'll finish it this week. And then there are cases that announced ready today, still ahead of Denike. So it may not even, you may not even get the fun email saying, hey, you're on this short list, so be ready.
Magic, so that's fine.
Okay. Well, that tends to happen more when something is actually about to be called out than if it's just sitting there. So we'll see if it gets added to the list.
Judge, did we determine if you're not right, just,
I don't see him. Is he the young man where, we'll let Ms. Gordon explain what's going on.
as soon as it was surprising him, his case was supposed to come to us.
Yeah, because he aged out.
Right. He hasn't reported,
Oh,
but it's a good thing because,
oh,
um,
you don't usually say that.
I know, RYDC didn't send us his case, so it's not in our system.
Okay. So if he showed up, they wouldn't have been,
Right.
who are you?
Comes because I need to get everything so I can send it, have it put in our system. Once I do, then he was officially on the clock.
Okay. Well, maybe he will show up virtually or something, or Ms. Gordon can help connect him with DCS. That would be good. Ms. Smith, did you and Ms. Shelton talk about, oh, she's back there. Hey.
Yes, Judge, we did speak. I am waiting to speak to my client who's being brought over from Cobb County.
They're up now.
He's here now.
He is. So when we are, we will be in a little while handling a fairly long plea with no inmates. And so with two deputies, you ought to be able to be back there to speak with Mr. Rakestraw.
I did not need to believe in oil, but can I do a goal before the very long page?
Mhm.
And as an is what I'll pass it down quickly. That's all.
Sure.
Outside of the clear, as long as don't make up, I am, so I have no objection.
Good to know.
Go back to proper.
Oh, that's right. I got your stuff. Is that on track?
Well.
I'm waiting for the end of the week announcement. I'm like, oh, I can't be ready.
It's got a filing, but it's not something we would get. Mr. Banks just filed for the defendant's medical records from us, but
Meaning he
wants them, but we obviously would not, we don't,
jail medical records?
no.
Okay.
Great, so
Okay.
I'm gonna, I was actually just about to text him now,
All right.
but other than that, state's ready.
Great. Mr. Aurora.
I sent you an email on Saturday with documents I gave the government a while ago. I got hard copies, it's both waiting.
You did. I printed out to me the most important part.
Okay.
I read it.
All right, I'm gonna get these, but can we do it under seal because it's all manual records?
Yep.
35.
Yep.
I'll just hand you the hard
Okay.
copies.
This is my set, or this is what I'll ultimately get to Ms. Rivers and file under seal?
Those would be the file copies.
Okay.
Taking off of them.
Okay.
The only thing I added is just the certificates of completion that I didn't do with the Red Party. Spent 6 months going through their learning challenges and all that. And I couldn't get to the owner to show.
Yeah, I know that guy. It's all right. I figured he was at the Super Bowl.
Probably, yeah, he moved in Francisco, but yeah, if that could just be under seal.
Yep. All right.
Position 6, Judge.
Good morning, Mr. Ramirez Perez.
Yes, señor Ramírez Pérez.
How are you?
¿Cómo está?
Bien.
Fine.
Great. I'm Judge McBurney.
Soy el juez McBurney.
Your
Nice to
case,
meet you.
nice to meet you.
Gusto en conocer.
Your case has been assigned to my division, and today is the day of your arraignment.
El día de hoy es el día de la lectura de los cargos. Okay.
Ms. Wood, is Mr. Ramirez Perez entering a plea of not guilty at this time?
Licenciada Wood, el señor Pérez, Ramírez Pérez se va a declarar no culpable ante estos cargos.
Yes, Judge.
Sí, estoy segura.
Mr. Ramirez Perez, your lawyer will soon get discovery. That's papers, videos, evidence.
Del caso, eso quiere decir pruebas, videos.
In your case,
de lo que haya en su caso.
and she will share that with you.
Y ella lo-
So you can,
Thank you.
you're welcome. So you can understand more about the charges you face.
Sobre los cargos encarando. Ok,
Ms. Wood will file any motions on your behalf.
presentar todas las peticiones que hayan que hacerse de parte suya
And will negotiate with the prosecutor.
y va a negociar ella con el fiscal o la fiscal. Ok, thank you, I appreciate that.
Do you have any questions?
¿Tiene usted alguna pregunta?
No,
No, not for the moment being. Thank you.
Ms. Wood, anything else on behalf of your client?
No, Your Honor.
Parte del suplente.
Ms. Smith, anything from the state?
No, Your Honor.
Okay. We'll see you soon, sir.
Nos vemos pronto, señor.
Gracias.
Okay, thank you. Okay, the interpreter be excused, Your Honor.
Yes.
We don't need our handy interpreter for Mr. Lopez.
No, Your Honor, I received incorrect information about his skills.
All right,
So,
great. Yes, ma'am. Thank you so much.
Thank you, Your Honor.
thank you.
Take care. So you will file a waiver when you get a chance in
Yeah.
Mr. Ramirez's case?
Yes, Judge.
Okay,
And we can do Mr. Lopez.
do that right now, and then we'll do Ms. McClarity.
Perfect.
Good morning, Mr. Lopez.
Morning.
How are you?
Pretty good,
Ms. Wood tells me you do not require an interpreter. Is that correct?
sir.
All right. You were supposed to be in court here back around Thanksgiving of last year. You missed court, so I signed a warrant. That warrant caught up with you. And we're just making sure your case can still move forward here. Ms. Wood told me you've got a warrant from somewhere else.
It's Forsyth County.
Forsyth. Okay, so you'll bounce between here and Forsyth till we sort all that out. But in the meantime, Ms. Wood is going to enter a plea of not guilty on your behalf, which is waiving arraignment. The prosecutor in your case is going to get all the evidence to Ms. Wood so she can review it. She'll talk to you about it. If there are motions that need to be filed, she'll file those. And I will see you again either because we're arguing those motions or it's time to see if this is a case that's going to resolve short of trial. And if it's not, then we'll do a trial. Any questions?
No supervision in case for drug right.
No, this is this case. He has an undetected case, Judge, from my office as well.
Okay.
So when I get the discovery, I'll be out to copy to you and we'll talk about this, okay?
What are the unindicted charges?
Drugs.
Okay. And what's going on in Forsyth? Is that an old case?
That's an old case. See, I was locked up 2024.
That's good.
Okay, it's an old case.
Yeah,
Okay. Is it something you're on probation for or it's not resolved?
no, it's not so.
All right, so I don't know how soon you'll get up there because you're with us now. We want to make sure this case is moving forward. But we'll be working on, it sounds like 3 situations. Okay? All right, we'll see you soon.
Thank you, Judge.
So you're gonna bring Ms. McClarity out? She can sit, whatever she needs to do, we can do. Good morning, Ms. Rivers.
Good morning. How are you?
Well, I have a cold and that's annoying, but otherwise I'm all right. Thanks for asking. We're going to get on the record. This is position 7. It's 25 SC 007-831, State versus McClarity. Ms. McClarity is in court with her lawyer, Ms. Wood. And I think Ms. Willingham, you're handling this for the state?
Yes, Your Honor.
Okay, thank you for doing that. Good morning, Ms. McClarity.
Good morning.
How are you doing?
I wish I could be better, but
Yeah, well, we're going to talk about that today. Ms. Wood filed a motion to reduce your bond. We were hoping to hear that before you had your child, but that came first. And I think that's going to be part of the discussion and your needs and your child's needs. Was it a little boy or a little girl?
a boy.
Okay, is that your first boy?
No, it's my third.
Your third boy, okay. And what is the little boy's name?
Montavious.
Montavious, all right. Well, congratulations on that. Is he in good health?
Yes.
Good. And how are you recovering? Medium. Okay. Well, Ms. Wood is going to tell me about what your bond should look like. I'll hear from the prosecutor as well, and we'll figure out if there's a way to move forward. Ms. Wood?
Thank you, Judge. So Ms. McClarity is 32 years old. She is a lifelong resident of Atlanta. She is a high school graduate and she did some trade school after high school. She was most recently gainfully employed at Piccadilly's. Judge, she does have 4 children.
4, including Montavious?
Yes,
Okay.
including the newborn.
Okay.
I believe, if my research is correct, I believe this is her first and only arrest. Judge, as I said earlier, I had reached out, Ms. Williams and I have already begun talking about this case. And I know, generally speaking, I don't request a bond if it's already headed towards a resolution, but given her health concerns, I think it would be best for Ms. McClarity if she's able to be outside of the Atlanta City Detention Center to recover from giving birth. She does have some underlying health issues. She suffers from asthma. Judge, she's been in custody 82 days. She's got a $25,000 bond. She just cannot afford. She does have a good address. She's told me that she's able to return to the apartment she was living at. I believe she had like paid in advance or there had been some sort of agreement that was worked out, Judge.
Is that the Scott Street address?
Yes.
Okay.
I did speak with Ms. Willingham this morning. I believe all 4 children should be in the custody of DFACS. So for now, a no contact is appropriate.
So Montavious is already in DFAC's custody?
Well, my husband's sister's supposed to be getting him.
Is he still at the hospital?
I believe so, but I'm not sure.
So he is potentially still a Grady judge.
Okay.
And then I just wanted to point out that the co-defendant / her husband and the child's father is still in custody.
Yeah. Okay. So Mr. Walker is the father of Montavious?
Yes.
Okay. So what are you recommending, Ms. Wood?
One moment, Judge.
Can't do nothing while I'm in here.
Okay. Your Honor, so Ms. McClarity is unfortunately just not able to make any monetary amount. So she's asking for a UJR on this case.
Okay. All right. Ms. Willingham, good morning and thank you for filling in for your colleague.
Good morning, Judge. We were willing to consent to a bond in this case, as I have been in communication with Ms. Williams this morning. I know that prior to the defendant being brought out, Ms. Woods had not had an opportunity to speak with her about an amount. I heard the UJR. The state's biggest concern would obviously be just that the defendant has no contact, as we still need to communicate with the caseworker. But defense is correct in that the defendant does not have any other criminal history. So we would defer to the court. And let me look.
I'm just looking to see if cruelty to
That's
children.
What I was just gonna say was whether it is actually UJR eligible.
I think it is. Oddly, the legislature said cruelty to animals, no UJR, but cruelty to children, yes, UJR. Okay. I'm just checking again. Well, except, there is 17,612A1 double A says no UJR for crimes involving family violence. And I think,
There are two battery.
correct. So I don't think those could be UJRs. They don't have to be large numbers, but I appreciate Ms. McClarity that any number seems like a large number right now. Ms. McClarity, do you know where your other children are? I know they're in DFACS custody, but do you know with whom they are staying?
I don't, I heard the names recently, but you know, I forgot the names. But we just had a court date for you know, my kids.
Okay,
They doing well.
good. How old are they?
11, 4, and 1.
Okay. Is Mr. Walker the father of any of the other kids?
Jace Walker.
Is that the 1-year-old?
Yes.
Okay, so the 4-year-old and the 11-year-old, different father.
Yes.
Okay, not Mr. Walker.
Mhm.
Okay, were all 3 of the kids staying with you at the time whatever this situation is about happened?
Yes.
Okay. Okay. Ms. Wood, anything else on behalf of Ms. McClarity?
No, Your Honor.
Thanks. Ms. McClarity, I will modify your bond by lowering it to $1,000 for counts 1 and 4 and $250 for counts 2 and 3. So it's a total bond of $2,500. And I'll keep that as a cash or good bond. So friends or family members can work with a bonding company to see what they might want in exchange for posting that bond. But that's 1/10 of your current bond. I can't set a signature bond. We also call that UJR because of a couple of the charges that you have. I don't think that's appropriate given what the allegations are anyway, but this is a significant lowering, and I'm hopeful that friends and family might be able to help you get over that hump. If not, Ms. Wood, let me know after a few weeks, and we will talk about it again. Also, keep me posted about Ms. McClarity's health, because if recovery proves to be a challenge, then that's another reason to come up with a different approach.
Thank you, Judge.
Okay, Ms. McClarity, and it will be a special condition of that bond that well, it's already on there, that you have no contact with the 3 children who were with you at the time, okay? Any questions about any of that?
No.
Okay, Ms. Willingham, anything else?
No, Your Honor.
All right, thank you.
Thank you, Judge.
Yes.
Ms. Rios, are you ready for Mr. McGlone?
Yes.
All right. And then we will do La Chapelle. Ms. Wood, you'll do a waiver in Ms. McClarity's case when you get a chance. Thank you. And then if you want to hop on with Mr. Harris now, that would be great. Ms. Rios, tell me what we're doing. Are we going to talk about setting aside the bench warrant? So we should get on the record? Okay, then we're on the record with positions 13 and 14, 25 SC 005805 and 25 SC 006410. Both are Mr. McGlone's case. He's here in court with Ms. Rios. And we've got, I think, two different prosecutors for the cases. Ms. Nix, you have the aggravated, oh, she's gone.
She stepped out, but yes, Judge, she has the aggravated stalking and I have the aggravated assault.
Okay. Are we okay going forward with Ms. Nix not here?
Yes, Judge, as to the aggravated stalking, that case, the defendant had not, we weren't set for plea and arraignment. So this was just his plea and arraignment today. There should not have been a warrant on that one.
Right, she mentioned that. Okay. So Mr. McGlone, we're just going to talk about whether I should set aside a bench warrant. It looks like you have bond in both your cases. Why don't you tell me what's going on, Ms. Rios?
Yes, Your Honor. Mr. McGlone is 33 years old. He has an address now that I can provide the court. He's worked at SpeedX as a forklift driver. He has his forklift license. He has two children, two girls, 11 and 5 years old. As far as the missing court, he had a different address. He didn't get notice when he moved. So he moved and had a different address. I think like a lot of people misunderstand that when you do a forwarding address, does not change the address in the court system. But I have address that I can give the court. So he will be attending court going forward. And I also have family contact with his number.
Okay. I've got an address on King Road in Riverdale and then an address on Marywood Drive in Fairburn. Is either one of those the new address?
As the King Road is the new address.
Apartment 1?
Yes, sir.
Okay. Who stays there, Mr. McGlone?
My mother.
Your mom? And that's where you would stay?
Yes.
Just your mom? You and your mom?
Yes, mom.
Okay. Does she work?
Yes.
What does she do?
She does dietary at Emory Hospital.
She does what?
Dietary.
Dietary?
Yeah.
Got it. And how long have you been doing the forklift driving?
I've been driving forklift for maybe 10 years, but at this job too.
2 years?
Yes.
Okay. And you think that job is still there?
Yes, I should be able to get that job back.
Should as in 50-50?
Or 75-80.
Okay. All right. So when did you move from the Marywood Drive address?
Marywood Drive, I've been going since the beginning of 2024.
Okay.
Going on 2 years now.
Okay. And Ms. Willingham, you're not concerned. I don't know what's behind the ag stalking case, but I appreciate that he got a bond.
Judge, I have lots of concerns.
Oh, okay. All right. Well, then let's hear from the state.
So, Judge, the defendant, although he did not appear for our case, he also did not appear for a trial in the state court on another domestic violence case with the same victim. In fact, Judge, there are a total of 4 open cases, 2 with the state court and 2 here in Superior Court, all with Ms. Williams as the listed victim. I believe the 2 in state court are battery family violence. And then we have our aggravated assault here as well as the ag stalking.
What's the basis of the ag stalking? I'm just surprised that there's a bond on that case if it's connected to any of these other cases.
Judge, let me go back. I know it's one of these cases. The basis of it is gonna be the order in one of these cases. I'm not 100% sure which one.
Okay, I'm looking at the indictment now. Pretrial release, it doesn't, but I guess he was maybe on pretrial release. On the other indictment.
Yes, Judge.
Okay,
And then, Judge, as to, I heard the defendant mention his address change. We actually, Ms. Rios and I actually, were going to try and have the defendant walk in, and he didn't appear even for that. But at that time, he was aware that he had missed court in state court, as the victim was actually sitting there all day that day, waiting for the defendant to appear because they were set for trial.
and there's no bench warrant out of state court?
There is a bench warrant, so the defendant is actually being held for that as well. So it's not there, he's not in custody just on our bench warrant. He's also in custody for his FTA in state court. And I can give the court all of those case numbers if you'd like, but we would strongly object to recalling the bench warrant in this case, as if the defendant would have walked into our plea and arraignment, he was going to be taken into custody that day anyway on his FTA for his trial.
Got it. So I could set aside the bench warrant and Mr. McGlone would go nowhere because he has to see Judge X, whoever the state court judge is, who was waiting for him to show up for trial.
Correct. And of course, Judge, even aside from his failure to appear, we would also be concerned about his contact with the victim in this case. We have 4 open cases, all domestic violence, and she is the victim in every single one of them.
Okay. When you interact with her or your colleagues, is she saying, I want Mr. McGlone out and I miss him, or I am so glad he is where he is because then I have peace of mind?
Judge, she is indifferent about whether or not she feels this should be a in custody case, but what she is not indifferent about is that she wants absolutely no contact with the defendant. Her and I spoke initially back in October when we were originally set, and at that time I did express to her, and she is logged on the Zoom, but she doesn't wish to speak.
Okay.
But at that time we discussed that I expected this to be a in custody offer. She's okay with that. She, however, would like for our office to make that ultimate decision, which, as Your Honor is aware, that's not uncommon in domestic violence cases.
Okay. Got it. We do have someone on from pretrial. Good morning.
Good morning, Your Honor.
Can you share with me, please, criminal history information on Mr. McGlone?
Yes, there are 5 arrest cycles. No felony convictions are listed. There's an open case from 2024 in state court for 2 counts of cruelty in the third, battery, family violence, and criminal trespass. The case number is 24 CR 001 0E. And there's also a 2021 open battery, family violence, also in state court. The case number is 21 CR 002 933E. Nothing further.
Got it. Thank you. Ms. Rios, it sounds like dealing with a bench warrant here is sort of incomplete relief, and it may make more sense for you, and I trust you've got a counterpart working on the state court cases, to confer to see if there is a more complete resolution of everything that's going on.
Yes, Your Honor.
Okay. Mr. McGlone, I'm not saying no, I'm saying not yet. There is a bench warrant from state court, as you've heard, and Ms. Rios needs to talk to the lawyer who is working with you in those cases to see if there's a way maybe we can address all these. And I will add this, Ms. Rios, if for some reason you and your client want to resolve all of them, probably could take pleas or manage the state court cases here. I could just talk to the judge there and say, can we consolidate all this for purposes of a global resolution? Just so that your client's not having to hope that what happens here carries over into a different courtroom.
Yes, Your Honor. Thank you.
Okay. All right. And in terms of waiving arraignment, I guess these are both arraignment days and you will get waivers in for both cases?
I already did.
You probably did.
I think I did see them, Judge.
Yes. Wow. One of them, I guess for the ag stalking, that was back in October. You probably did it for the other one as well. And then we didn't catch up with Mr. McGlone. All right, Mr. McGlone, any questions about what we discussed?
No, I know I had a bond for one of the FTAs, so I'm just not gonna get the bond for the other one at all.
Not yet.
Not yet.
Ms. Rios needs to talk with the prosecutors, both here and in state court. And it may be that she wants to try to resolve everything. But if all the other holds go away, we should come back and talk about this one. When this is the only hold left, we should talk about it. But there's a whole nother one that looks like it, based on when it happened, and I don't mean when on the calendar, but when in the process, trial, is probably not going anywhere until that case resolves. Okay? Thank you. Yes, ma'am.
And Your Honor, that concludes my business. May I be excused?
Yeah, thank you for filling in for your colleagues. All right, we are going to handle the La Chapelle plea now. Mr. Aurora, if you and your client want to come on up to the podium, and Mr. Bridges, you can migrate forward one. I will be right back. I'm gonna get some more cold medicine.
The emergency fixes everything.
Oh, okay, what happened to our, okay. Deputy Gordon will reappear, so he may have been taking Ms. McLarity downstairs because of her medical situation. When he pops back up, wave your hand or remind me. I'll try to remember to get you back there to see Mr. Rakestraw. Oh, look who's here. Ms. Shelton would like to meet with Mr. Rakestraw.
Easier than the rest of them.
Okay. When he is out of that mode, then you can chat with him.
Okay.
I did.
There'll be a good bit of family on the video, just in case you wonder who all the people are.
Okay, great. They are welcome to join, and if there's time when they need to add something, we can activate them. I will be right back. Get going.
And then when you get it approved, okay, I'm gonna put you in. Alright.
Sorry. All right.
Yes, sir. No, just a DUI. Okay. Stop here. You're protecting cameras. What's your team? I'm gonna say it. I'm gonna get them back.
Oh, that's mine. I asked Miss Nelson. Yes.
So that's gonna be this next. We should have put in your address and information actually. His dad will just fill it out for it if you don't mind. They'll just make it easier. For sure.
Yes.
So she would be my PO. Okay. You signed me my PO. Okay.
All right. Let's get on the record, please. This is 25 SC 002-666, State versus La Chapelle. Mr. Aurora is here with his client. We have Mr. Bridges for the state, and it's my understanding, Mr. La Chapelle, is he going to be standing with you, or he can stay seated? It just, we need to, I think it'll be easier for the court reporter if he is up at the podium.
Sam, I want you to talk
Great.
into the microphone when the judge asks you a question, okay?
Can you adjust the screen, Deputy Gordon? Thanks. So Ms. Rivers can see. Great. So Mr. La Chapelle, good morning.
Good morning, Your Honor.
I'm Judge McBurney. We've met virtually. You were on a screen last week or the week before. You remember that?
Yes, Your Honor.
Great. I appreciate you being here and I appreciate your patience. In a moment, Mr. Bridges, who's the prosecutor, he's the gentleman over to my left, is going to put you under oath and ask you a bunch of questions about your case and your rights, all things Mr. Aurora has already discussed with you, okay?
Okay, Your Honor.
You'll need to answer his questions truthfully, and you'll also need to let me know if you have questions of your own. Will you do that?
Yes.
If someone says something that confuses you or you just don't understand, you'll tell your lawyer or you'll tell me?
Yes, Your Honor.
Okay. Mr. Bridges, before you put Mr. La Chapelle under oath, is this a negotiated or non-negotiated plea? And is it to all the counts in the indictment or some? Okay. All right. When you're ready.
Mr. Chappelle, can you please raise your right hand? Do you swear or affirm that the testimony you shall give and the background before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Could you please state your true and correct legal name?
Hold on.
Put the microphone in front of you, please.
Samuel Robert LaChapelle.
Okay, Mr. Bridges, I need you to bend the mic. There you go. So Ms. Rivers can hear you. Great. Thank you.
Could you please state your true and correct legal name?
Samuel Robert LaChapelle.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
How old are you?
41.
And how far did you go in school?
Graduated high school.
Are you able to read, write, and understand the English language?
Yes.
Do you understand you're currently charged in indictment number 25 SC 002-666 with 15 counts of possession of control of any material depicting a minor and sexual explicit conduct?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes.
You understand that you have the right to plead guilty or not guilty or remain silent and receive a jury trial?
Yes.
Have you reviewed the waiver right form and all known plead guilty forms from your attorney?
Yes.
And I have here this form right here. Did your attorney go over this form? Plead guilty?
Yes, sir.
And this is your signature on this form indicating you want to hear it.
Yes, sir.
Have you had enough time to speak with your lawyer about all the facts and circumstances known to you regarding the charges of this indictment, including any potential defenses?
Yes.
Do you need more time to speak with your attorney about this case?
No, sir.
Are you satisfied with his representation?
Yes, sir.
Counsel, do you waive formal reading of the indictment?
We waive.
And do you waive any all defects in the indictment, including in respects to the client's, including respects to your client's name?
Yes, for purposes of this plea, we do.
Mr. LaChapelle, have your attorney advised you that in this indictment, you're charged with 15 counts of possession of control, sexually explicit material? Do you understand that for each count that you can be sentenced up to 20 years, minimum of 5 years?
Yes, sir.
You understand that do you understand neither the court nor the district attorney office has any say in parole, the parole department correction, the board of pardon cannot guarantee parole in this matter?
Yes.
Do you understand that this is a blind plea, which means the state will make a recommendation and your attorney will make a recommendation. In the end, the judge will make a decision on what your sentence would be?
Yes.
Do you understand that if the court decides to order a sentence that differs from the blind plea, from what we've recommended, you have the right to withdraw that plea?
Yes.
You understand that you're currently on probation or parole. Your probation or parole may be revoked based on you entering guilty plea today.
Yes.
Do you Mr. LaChapelle, are you a United States citizen?
Yes, Your Honor. Sir.
Mr. Bridges. Do you understand that there may be other adverse or unfavorable consequences as a result of guilty plea conviction, just as it would be for conviction following a trial?
Yes, sir.
You understand your right to vote, your right to hold public office, your right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or your ability to get employment may be affected by you entering guilty plea today.
Yes, sir.
You understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony which may carry a sentence to 1 to 15 years in prison.
Yes.
You understand that you waive any of all defenses, including any mental health defense, by entering guilty plea today.
Yes.
Do you understand that that you waive the following rights by entering guilty plea? Do you understand you waive the right to plead guilty? I'm sorry. Do you understand that by pleading guilty, you are giving up the right to a trial by jury?
Yes.
You understand that by pleading guilty, you're giving up the right to remain silent and not incriminate yourself?
Yes.
You understand that by pleading guilty, you're giving up the right to confront witnesses against you?
Yes.
You understand by pleading guilty, you're giving up the right to assistance of counsel, however, your court-appointed counsel if you cannot afford attorney at trial?
Yes.
You understand that by pleading guilty, you're giving up the right to presumption of innocence?
Yes.
You understand by pleading guilty, you're giving up the right to testify on your own behalf or present other evidence?
Yes.
You understand that by pleading guilty, you're giving up the right to subpoena witnesses and compel the production of evidence?
Yes.
You understand that by pleading guilty, you're giving up the right to have the charges against you proven beyond a reasonable doubt?
Yes.
You understand that by pleading guilty, you're giving up the right to appeal if you're convicted of these charges after trial?
Yes.
Has anyone forced you, threatened you, or promised you anything to enter a guilty plea today?
No.
Is this decision to waive these rights and enter a guilty plea freely and voluntarily given?
Yes.
How do you plead to the charges in indictment number 25 SC 002666?
I'm pleading guilty.
And is this guilty plea freely and voluntarily given with full knowledge of the charge against you?
Yes.
You understand that you may have only a limited time to appeal this guilty plea conviction?
Yes.
You understand that do you understand that unless counsel is substituted or permitted to withdraw, you would be represented until the end of the current term of this court or 30 days from the date of the entering this guilty plea today?
Yes.
You understand that you have only 4 years today for a felony to file what we call a habeas corpus challenging the constitutionality of this guilty plea today?
Yes.
You understand that any of these files you have discussed, any of these filings must be discussed, filled by your counsel unless represented by someone yourself?
Yes.
Yeah, there was also, Mr. Chappelle, you filled out the Department of Community Service mandatory submission of polygraph,
Yes, sir.
and you also filled out the Department of Community Supervision additional conditions for probation.
Yes, sir.
Trying to monitor. And you also filled out the sexual offender conditions probation,
Yes, sir.
and you filled out the computer restrictions.
Yes, sir.
Your Honor, had this matter gone to trial, the state would have shown that on October the 19th, 2022, Roswell Police received a cyber tip from the National Center for Missing and Exploited Children. That cyber tip indicated that there was material in there which related to a individual downloading child pornography. Further investigation led to them identifying the IP address, and then they obtained a search warrant from Yahoo and were able to identify the individual that the account came back to. And it came back to Mr. Sam LaChapelle, and it gave his phone number, date of birth, and his address, which with IP address and address where the download occurred. Further investigation, Your Honor, indicated that Mr. LaChapelle had downloaded a number of files. In the end, when they finished and they got a search warrant for the location, that with the location, Mr. LaChapelle was there. They identified the devices that belonged to Mr. LaChapelle, and they were able to get another search warrant to actually examine those devices. Upon examining those devices, they downloaded 30 images of child sexual abuse material. We only charged him with 15. But the nature of the videos, due to the nature of the videos, Your Honor, is why the state is making a recommendation in this case on each count, 10 years, 20 years to serve 10 years, balance on probation, special conditions as he signed up for, In addition, pay a $10,000 fine, no contact with minors or no pornography material, comply with all supervision of probation. In addition, no access to social media or gaming websites during the period of probation. And that would be the state's recommendation, Your Honor.
Okay. Do you have information, Mr. Bridges, as to where the images or the videos were found on a phone versus a hard drive on a computer?
Yes, Your Honor, I do. I think it was a hard drive or computer.
Just to make it easier, Your Honor, it was on the phone, but it forwards to his laptop. So, you know, like when you get your iMessages, it sort of goes to your computer and your phone.
It was cell phone and laptop.
We
Yes,
have it,
correct.
it's originally on the phone with the Kick app, but it forwards to the computer just like your
Okay.
emails.
It was located in Mr. LaChapelle's bedroom.
You mentioned the state charged 15 images or videos, items, but 30 were found. Is 30 the entire universe of, we'll call it CSAM for purposes of our hearing, child sexual abuse material? Was 30 the entire universe of CSAM items that were recovered after a thorough search of both the phone and the laptop?
Based on the report I have, Your Honor, 30 was the number of images located on the cell phone and laptop.
Okay, thank you so much. Ms. Washington, can you share criminal history information for Mr. LaChapelle, please? Did you get that calendar?
I did.
Great.
There are 4 arrest cycles with multi-state interaction in Wyoming and in Georgia. There are no felony convictions that are listed.
Okay, thank you. While I'm thinking about it,
No. Good.
what's the Wyoming connection?
That was, when I was living there, I had a misunderstanding with, I was dating this girl and apparently, this older gentleman had an obsession with her, my fiance at the time. And as I was helping her in my car, he came to the ability to, defend her in his sick little mind.
Okay.
And he decided that I was going to abuse her or whatever the case may be, and he called 911 on me.
Okay, I appreciate that's more detail than I was expecting to get. What's your connection to Wyoming? You were there because that's where your fiance was?
Yeah, she lived there.
Okay.
I moved out there and.
Okay. How long were you in Wyoming?
About a year and a half, maybe a little less, maybe a little bit more. It was so far ago. It was when I was in my 20s.
Since then, have you always been in Georgia?
Yeah, Georgia and Florida.
Florida. What's in Florida?
I was living there and working there in Florida.
What kind of work?
Fast food during the pandemic, and I needed a break, and my parents had a beach house at that time, and I decided to make a change for a little bit.
So you stayed at your family's beach house in Florida and worked for a while?
Yeah.
Okay.
I'm always working.
Okay. Mr. Aurora.
Yes, sure. All right, so there's a universe of 30, and as the prosecutor said, the link from the Child Abuse Center went out in 22, but the videos I think were from 2020. When they were all sort of downloaded and then the images went out, and then in 2023, they finally decided to search the phones. The one thing I would point out is, aside from what we'll talk about, the mental health type issues, I don't think they rise to the culpability, but certainly it's a mitigating factor that I'm going to ask the court to consider. But he used his own information. There's not too many CSAM cases I'm certain the court has where it's not I like so-and-so.com or whatever versus your own name, your own everything. There's no hiding anything. This wasn't a dark web type of situation. We'd hired a computer expert to talk about what was downloaded, what was seen, because generally once you get into the thing and you get 1 or 2 photos, they start coming. And so our position would be, I don't know if he actually saw all of them, but they're there and that makes it a problem. But versus getting into the weeds with you, I just wanted the court to know that that was part of our defense. But as long as he has one that he's seen, which he has, that would sort of put us where we are here today.
Mr. Bridges, the NCMEC report to Roswell Police and Roswell Police's investigation. Do you know if either NCMEC's findings or Roswell Police's work revealed that Mr. LaChapelle was trading in these images as opposed to, I don't mean to minimize their impact or anything like that, but he merely, I use that term very lightly, he merely possessed.
Yeah, I'm gonna say no, because we would charge him distribution.
Okay, got it. Your focus is, and your contention is, he had this stuff, and that's a crime, and it raises all sorts of alarm bells, but no reason to think he was would have been a very small collection to be trading, but that he was a distributor.
No, nothing
Okay.
what I see, yeah.
Thank you.
And also, it was, I know the link went out in 2022 and it was investigated in 23. I'm not sure why it took so long, but for those years, it was just that one. I don't want to say aberrant behavior like we say in federal court, but the court understands it hasn't happened since that time. Most of these things are several years old. Does the court want to hear from the witnesses that we have now, or should we finish up the plea, or how would you like to go forward?
So I think it would be helpful to hear what you want to share in terms of mitigation.
Yes, sir.
Mr. LaChapelle, do you take any medications?
No, Your Honor.
Okay. Have you ever taken medication for any diagnosis that you've received in terms of either a physical health diagnosis or a mental health diagnosis?
Yes.
And what was it that you took?
My past is Ritalin, Adderall, Concerta when I was younger for my ADHD, ADD medication.
Okay. And why do you not take that anymore?
I feel no need for it.
Did a doctor continue to recommend it and you said, I'm not going to do it? Or you were evaluated and the doctor said, you know, you're doing okay, even without the medication?
I just felt, me personally, I didn't need it anymore. I wasn't going to school, so again, I felt like I grew out of it. I'm not expert. I don't have a medical degree, but I felt like I no longer needed it.
Okay. Thank you for sharing that. So, Mr. Aurora, I have reviewed the materials that you provided, and I share that only because if you want to streamline things, I've absorbed what the evaluators had to say and what the Highland Institute's assessment was and what their recommendations are.
And so just for the record, if we could admit that as one exhibit under seal, since it's got a lot of private information.
Sure. So I have in my hand a set of documents that you gave me earlier this morning that includes all the things you emailed to the state and to me, evaluations from different medical professionals, along with some certificates of completion. And I will file these under seal as part of this case.
And we also had the polygraph that he took to
That's right.
address the court that we didn't touch anybody. It wasn't, as the prosecutor correctly said, you know, trading or recruiting.
That's right. I read the polygraph report.
And so with those items, just for the record, we've also completed a 6-month diversion program to sort of get some type of adult intellect to understand how to make decisions, compulsions, those types of things. I think Your Honor is familiar with that program. I'm not sure. We've had the psychosexual evaluation from the most pro-prosecution group I could find because they use it in the federal system, which is the Highland Institute. And ideally, I would point out the last couple of paragraphs after they give you the long evaluation is that he would not survive in prison based on his essential mental status. Again, that doesn't negate guilt or innocence, but it certainly should go towards mitigation and what would happen to him if he was in custody. We also took the polygraph issue and then the 2 autism. So I would ask the doctor to come on up. I'll have him testify briefly with regards to the chart, just sort of give you a summary of where it is for the record.
Okay.
And then let Your Honor ask questions or if the government has any.
Sure, or Mr. Bridges has anything. That's great. Thank you for these. I'll make sure they are made part of the record. Plea of guilty. Okay, got it. And Ms. Simpson, did those forms go back to you or do I give them to Ms. Nelson to file? They come with you. Okay, got it.
Sorry.
Sorry.
You raise your right hand. You swear affirm that the testimony you will give You prove the whole truth, nothing but truth, self God.
I do.
Good, yeah. Can you state and spell your name, right?
My name is Tyler, Tyler. Middle initial T, last name Whitney, Whitney.
All right, and you're a doctor,
That's correct.
all right, and what is your specialty, Dr. Whitman?
My specialty is neurodevelopmental disorders or disorders of childhood.
Your Honor, I've talked to the prosecutor. I'm just going to lead him a little bit so we can get to it, not take
It's
up
a
time.
sentencing hearing, that's fine.
All right. Just a quick background. I know you said you specialize in neurodiverse, and we've talked that you worked in other states and things like that. Can you just give the judge a little background as to how you've dealt with neurodiverse individuals and any substantial accomplishments?
Absolutely. I graduated in 2001 from the Forrest Institute of Professional Psychology. It's a professional school that is associated with the University of Missouri at Columbia. It is a specialization in clinical psychology, a PsyD, as opposed to a PhD. It is a clinical version of a PhD. I was initially trained as a clinical psychologist, spent time in a rehabilitation hospital. During my internship, my fellowship years were in psychometric testing of children, adolescents, and young adults. And then my formal fellowship training was in autism spectrum disorders. And I did a fellowship through the HRSA grant, through the LEN program, Leadership in Neurodiversity, through the UR-LEN program, which includes 5 states, including Utah and Idaho, which is where I was to begin my practice.
Right. And you're also affiliated with the Emory program with regard, if you could just tell them, I don't want to put words in your mouth.
Absolutely. I am an adjunct associate professor with the medical school at Emory. I am assigned to the psychiatry and the law program under Dr. Peter Ash's direction. I am the individual that they go to whenever there is a developmental issue that is involved in the legal system in the state of Georgia. As you said, I also testify around the country in state and federal courts. When I came to Georgia, my focus was on clinical practice. About 70% of my practice was clinical, and I saw children, adolescents, and young adults. And over the last 13 years, my practice has morphed so that about 30% of my practice is clinical and about 70% of my practice is forensic because of the extreme nature of electronics and the population that I serve.
With regards to neurodiversity, have you seen a sharp uptick based on neurodiverse individuals getting sucked into issues that are online that we didn't used to see before in the early 2000s?
Absolutely. Anytime that you have individuals that struggle socially and they are ostracized, sometimes in person, mainly in the schools, sometimes in their neighborhoods, those types of things, the natural tendency is to go online and to look for ways in which to socialize. For males, it's typically pornography, video games, and gambling. For females, typically it's social media and the like.
With regards to Mr. LaChapelle, did you have a chance to treat him?
I did. I had a chance to evaluate him and to advise as to what would be appropriate and what would be inappropriate.
All right. With regards to the issues, I have a neurodiverse son, so I understand a lot of this. If you could tell him about the loneliness and all that, is that what sort of pushes you towards this online world and things can sometimes get out of control?
Absolutely. And as we've talked about, things are difficult in terms of the way that Mr. LaChapelle takes in and ingests information. One thing I would bring to the court's attention is he struggles to do things every day that most of us don't struggle. And one of the things that happened during our evaluation is he was asked to come to a new office address that I had. And it took him quite a bit of time to find himself at my office address, even though we were spending time on the phone. I was giving him direction, those types of things. Being able to sequence and organize the information that is given, even in a stepwise manner, is very difficult for Mr. LaChapelle.
And with regards to his social intelligence or social age, I know you put it in your report, but can you just sort of give us a quick 30,000-foot view of that?
Sure. I think that Mr. LaChapelle would like to be just like everybody else, as he stated. You know, he's been making some semi-independent decisions for himself, but I would find him in the range of an older elementary school student to maybe pre-adolescent, so between 8 and 13.
All right. We discussed a study where neurodiverse people had these issues with pornography, and you just sort of share the findings of that study with treatment and what the recidivism rate is to get back into this illegal activity.
There have been some changes in laws across the country. One of the places that's done a pretty good job of this is in Virginia. And some of my colleagues that are in Virginia, particularly an organization called D3 or Decriminalized Developmental Disabilities, has tracked 10 years of non-contact types of offenses that are online. And they have over 100 people in this study that have possession only charges, not distribution charges. And they have 0% recidivism over a 10-year period.
With regards to Mr. LaChapelle, understanding that he's essentially between a 9 to a 13-year-old intellectually, would prison solve anything from him if the court exercises its rights to jail him?
I think it would be disastrous if Mr. LaChapelle were to go to prison.
Why disastrous?
He doesn't have the ability to read people. He's been taken advantage of online from people that have claimed to care about him, love him, and the like, as well as people in person that have taken advantage of him. And there's a known increase in antisocial personalities that exist in prison. And when they pick up on these things, tend to be very quick to take advantage of those individuals.
What's your basis for saying that Mr. LaChapelle has been taken advantage of online and in person by others? He told you, or it's been reported to you from someone else?
Third party. He's had money extorted from him. He moved to be with his fiance that was in Wyoming. All of these things are not what the rest of us would consider to be legitimate or loving and caring relationships.
Okay.
And that's where the Wyoming issue sort of gets a little manipulated. Plus, you've got the information from his family and other.
I do.
When you talk
Anytime
to
that you do this type of an evaluation, you're going to get ancillary or third-party reports, plain and simply because you realize that the person that is reporting to you, that is the person that's being evaluated, has a different perspective on the world possibly than someone that's typically developing.
And your opinion as to how he would do in prison, I mean, sort
Not
of
well.
mirrors what the psychosexual evaluators did as well, correct?
Yeah, I really feel like anytime that an alternative sentence and the community can be kept safe, I think it's a win-win, especially where there's such a supportive family and he's been receiving the help that he needs. He was also evaluated by one of my colleagues, Dr. Celine Saulnier, who also is a very recognized expert in the field here in Atlanta.
All right. Judge, I don't think I have any questions that wouldn't be redundant if you or the prosecutor have anything to ask.
I'm curious, Dr. Whitney, given that you operate in the field of people who've become involved with the criminal justice system and are working through or have developmental challenges, I hear, oh, those people, they can't go to prison. Prison would be difficult for them. Prison is not easy for anyone. It is easier for some and harder for others. But are there not facilities in Georgia where someone who would be unduly vulnerable, a trans person, an elderly person, someone who maybe is on the spectrum to a certain extent, where they can be housed so that they are less at risk than if they were in general population and the fears that you have could be realized?
Yeah, I think that there is movement towards that. I am not aware of anywhere in the state of Georgia. In fact, the only two that I am aware of exist in the federal system.
Butner.
Yeah, Coleman in Florida is a medium security. And then there's one in Connecticut that is a minimum security that have actual autism programs. But as far as I'm concerned, and as far as I understand, there is not a state in the country that has a program for autism other than those two federal programs.
Okay, thank you.
And just based on my experience, we've had people like you mentioned in those categories. I mean, essentially they're 23 and 1 in isolation, which is where you sort of go for protection or punishment. And that's essentially what you do. And there's
Okay, to keep them safe, it becomes solitary, which is its own set of complications.
yes, sir.
Okay. Mr. Bridges, do you have any questions for Dr. Whitney?
State, Your Honor.
Okay, Dr. Whitney, I appreciate your time. I'm sorry we got a late start, but we had some other stuff we had to handle.
Thank you, Your Honor. I appreciate it.
And Judge, all the family members are here, but rather than have them talk, I'm just gonna have his father come up and address the court, if that's
Okay.
right.
And he doesn't need to be under oath unless you're going to be asking complicated questions. I'll let Mr. Bridges ask him questions if he wants to. I just soon he come to the podium unless there's factual evidence that you want to make part of the record.
I don't think there's anything factual except what their plan is for their son and what they've seen his behavior.
Okay.
That's. Maybe I'll just come to the podium. Sam, you can grab a seat while you're that time.
Thank you, Your Honor, for this opportunity to speak on my son's behalf. Sam and his family know how serious these charges are, and that Sam's pled to today. Sam is genuinely sorry for his actions. Since getting bail, he has followed the court orders on every account. He's had no access to the internet. He's remained gainfully employed.
I'm sorry to interrupt, but I'm not going to remember when you get further in. No access to the internet is a profound statement in this day and age. Tell me how you and your family impose that and enforce that condition.
Well, the best that we can through direct supervision, a phone that is not internet capable.
What does that look like?
Like a little flip phone.
Okay.
It's a Google phone. It's a Google phone, Your Honor. It's a small phone about that high, and it only does calls and texts.
Got it. So your son can make a call, which is an important thing to be able to do in life,
Text
and receive a text, but there's no browsing ability.
Correct.
Okay.
He's had no access to the internet, has remained gainfully employed, and has performed service for others. Even though Sam lost his job at Home Depot when he was arrested, he worked hard and replaced that employment.
What's the service for others you're referring to?
Well, most in particular, he's been contributing to our family. He has elderly grandparents who are sick, and he's been staying with them at night when my father-in-law has been in the hospital and in the nursing home. That's extended for about the last 3 months. And so Sam's able to be there for his grandmother in the middle of the night and then also help out when he's not working.
And they're local, your in-laws?
Yes, sir. He currently works at Ever Spirits in Marietta. And I think as you saw when you last interfaced with Sam prior to today, his job's very important to him. It's really his source of identity and a source of pride. He's a hard worker, he's punctual, and he's quite willing to volunteer and take shifts for others.
What does he do?
He works as a clerk in the liquor store and helps people find products that
Got it. If I was there and I was looking for red wine, he'd say aisle 4.
He'd probably take you over to it.
What kind of red wine are you looking for?
Yes, sir.
Got it. Okay.
You know, this, when we talk about people taking advantage of Sam, and I don't want to suggest that his coworkers take advantage of him. He doesn't feel like he's being taken advantage of, but he finds pride in you know, taking on an extra shift, and it gives him a sense of accomplishment, a sense of purpose. He's looking for that approval and that appreciation.
Does he drive?
He does, yes, sir. Outside of our family, really work is his entire social interaction for the most part. And that's important for his well-being. I mentioned working with his grandmother. the internet's just a horrible place. And you know, when you have a disability, you know, there's so many things that you're trying to overcome. And that makes no excuse for what has happened here. But you don't have true friends or a social life. And, you know, as a family, I feel like we should have been more vigilant. You wake up every day and you think about that. And we know what he did wrong. He's getting counseling, and as a family, we're here to support him. And I just appreciate the moment to speak to you.
Does your son stay in your household? Does he have his own place?
Well, presently, he's been staying in our home. He's been there since this incident has occurred. He's also lived with his aunt before. She was unable to be present today. I completed the form today that we're staying at our place, but he's actually needed at his grandparents' home presently. They're 15 minutes away.
It's all local. It doesn't involve going to Alabama or?
Oh, no, sir.
Okay.
You live in Roswell.
We live in Roswell, and my in-laws are in Marietta.
Okay.
What do you do for a living, Mr. LaChapelle, as far as being able, you and your wife or his mom, being able to monitor him and all those kinds of things that we've done for the last 2.5 years?
Well, I mean, I work locally here. I'm in commercial real estate business. And
so your household is in a position to support your son if there are requirements of his sentence that are expensive, that involve counseling, et cetera.
Yes.
Okay.
Yes.
I appreciate you being here. I know this is not an easy time.
Thank you.
You're welcome.
I don't have anything else except you can see the other folks. I didn't want to just pack the courtroom with folks. I just said they can do it online. And of course, his mom's also here and his brother's here as well.
Okay. And there's a Roseanne and a Sarah and a Maria. I'm assuming those are all people who are here to support him.
I can't see anything. I
That's
just
okay.
have 2 pictures here, so I don't know who's on there.
All right. You can see yourself?
I can see myself in the courtroom. That's
okay.
it.
All right. All right. Well, it's good to know that there is support for Mr. LaChapelle. The state is recommending 10 years in custody followed by 10 years on probation. What is your recommendation and why?
My recommendation would be straight probation because I think we've given the court a track record of over 2 years now as not having any issues. And in fact, it's been more than 4 years, I would argue, that since anything has happened, even though he was arrested in 2023, Your Honor. Being on the registry and all that is going to put a lot of issues for him, which is on top of what he's got to deal with. But he's lucky that he has got the DNA lottery. His parents have money, so they can, do this stuff. If he wasn't in that ability, I don't know what we would do, honestly. But we have the resources. We've got good doctors that are assisting him. And as you've heard from the sole study that's out there, it's a 0% recidivism rate as long as he goes forward. And we plan on following the requirements of no social media, things of that nature. It's made it hard to get any work because that's why he couldn't be on the phone, and I had to have one of my associates drive out there to put him on the Zoom.
Right.
We've managed with a flip phone, which it's really hard because you got to press everything 3 times to get a letter done. But he hasn't complained about it at all. And much like my personal experience, the job is everything for them because you really don't have friends in that situation, especially when this isn't necessarily functioning. I mean, it's a pretty high level of autism that he suffers from based on where he is. And I wish the mental health laws were a little bit better for us, but I just don't think he appreciates what he's looking at. And when you think you're a 13-year-old and you're looking at a minor, it may not be quite as offensive as you and I looking at something like that in their minds. It doesn't make it right. It doesn't make it wrong. We've corrected that. So he's gone through the programs to understand what right and wrong essentially is, or how we need to control ourselves.
Okay.
And so I know you could offer custodial sentence. I just don't know how that fixes anything or rehabilitates him. Either he'll get killed in there or he's just going to come out worse, would be my impression, because he'll be locked up in isolation. I mean, he has to survive.
Mr. Bridges also recommended a fine. Is that a mandatory? We move very infrequently in this statute. It was much more common on the federal side. And so I don't know if that it is jail or a fine or and a fine, so you can do both, or that that's a mandatory part of the statute?
When I look at subsection B8 and then you go down 3 more levels for punishment, I don't see it as a mandatory. Like every crime has the ability to fine.
Most.
And so he can't pay the fine. I mean, his parents will end up, paying the fine if that's what's necessary. I think we're going to be spending enough, make sure with the mental health stuff that he, can be a beacon of something and how to create this. I also work with the autism school here in Mount Vernon. And so we talk to their students too about computers and what to watch out for, because I've had multiple autistic cases that I'm dealing with throughout the metro area, and it's just turning into it's just blowing up because of the computers and where these kids are as far as that goes. But I would just simply point out, I know it's not distribution. Even if it was, I would still argue it's all under his name. It's not like he's smart enough to know to hide any of that stuff. And if just say hypothetically, if you go to any type of porn website, the stuff just starts coming, even if you look at one thing, on your computer. And so
I'll take you at your word.
Okay, I understand. And so respectfully ask, if we're going to rehabilitate somebody and do the right thing, this would be the one exception that the statute allows Your Honor to let him have a certain amount of probation so he can sort of survive and move on with his life, and his parents are here for him.
Okay.
Thank you.
The way I read 1612-100 F1 is that, I don't know what the words say, a violation of this, meaning possession of CSAM, is punished by imprisonment for not less than 5 nor more than 20 years. That's exactly the range Mr. Bridges shared, and by a fine of not more than $100,000, unless this is a member of an immediate family of the victim, and that's not this case. So it wasn't CSAM of a niece or a sister. So there is a fine. I guess I can decide what it is, and it can't be more than $100,000. But I'm mindful of your observation that that's coming out of the family, because Mr. LaChapelle, is probably not earning a whole lot more than minimum wage, even though he's taking these extra shifts.
Right, we're, I think, $13 an hour?
$14 an hour, Your Honor.
All right, that's nothing to sneeze at, especially in Georgia. Mr. LaChapelle, you have a right to add anything you want. You don't have to say anything. If Mr. Aurora has given you his thoughts about whether you should say anything, think hard about what he said. But you have a right to be heard if there's something you want to layer on top of what I heard from your father, Dr. Whitney, and your lawyer.
No, Your Honor.
Okay, I understand that. Mr. Aurora, you've said it a couple times, but I want to lock you in on it. You have done a lot of work with your client in understanding the scope of his developmental challenge, but I'm hearing you say that you believe that Mr. LaChapelle is competent to enter a plea and that he does understand what's happening today. It may be that he didn't appreciate the gravity of bumping into these images 4 years ago, 5 years ago, but he does understand the gravity of entering a plea to these charges. Is that a fair summary of what you've said?
Yes, Your Honor.
Okay. Mr. LaChapelle, I will accept your plea. I find there's a factual basis for your plea. Law enforcement found on your phone and thus on your laptop, because there was a direct backup, a total of about 30 images or videos of CSAM. That is contraband, that is illegal, that is hurtful, harmful material. The little boys and girls who are filmed in there are victims. Every time that images go somewhere else, that kid's re-victimized, whether you looked at it or not. And that's the real tragedy here, that those images can't be erased. They're going to circulate and circulate. Wherever you bumped into them, someone else is bumping into them, and those kids don't get to move past what happened to them. So I do find there's a factual basis. I also find that your plea is knowing, meaning you've understood what we talked about. Any questions about anything?
No, sir, Your Honor.
And that your plea is voluntary, meaning no one's forced you to enter this plea. You've decided it's in your best interest. Also true?
Yes.
Okay. Mr. Aurora, can someone in my office sign the indictment on your behalf?
Yes, Your Honor.
Mr. Bridges, can we sign for you?
Yes, Your Honor.
Mr. LaChapelle, is it okay if we electronically sign your name to the indictment?
Yes, sir.
Indicating your guilty plea to all 15 counts?
Yes, sir.
I want you to understand that I don't view this as more serious or less serious because there are 15 counts. That seems like a lot. There are different ways to charge it. The state could have charged all 30. They could have charged one. The focus I have is the size of the collection. And Mr. Aurora knows this. He may have shared it with you. I, for many years, prosecuted people federally who trafficked in and produced CSAM. And what you had on your phone is negligible. And by saying that, I do not mean that it had no impact on the victims, but it is evidence of an almost accidental glance, as in a browser hit a website. And as that website is popping up all the images, you get those on your phone. It is not evidence of an active pursuit of CSAM. Collections number in the tens of thousands, and people hide hard drives in closets and upload them to secure spaces. They don't have them sitting on their phone that's unprotected in an account that's in their own name. I don't find from the evidence that I've heard that you are an online menace, that you would share these images should you come across them again. I hope you don't, because you really shouldn't have access to Disney films online. You're not going to have social media, internet access beyond whatever happens. I mean, maybe at work, if you're using the cash register, that's sending a signal somewhere, but you're not browsing anywhere, anytime. It's unfortunate that you had those images. It's turned your life upside down. And as I mentioned, it re-victimized the 30 or more child victims that were depicted in the images and the videos. But this has none of the hallmarks of someone who was seeking this out and derived direct pleasure from it. It doesn't make it go away. There are going to be pretty serious consequences for you. You already face obstacles that most of us don't, because of the challenges you're wrestling with. Having to register as a sex offender only adds another layer. You are blessed to have a family that cares a lot about you and with the means to help you work through this. You do need to know this: there's not a second chance. If we are together again because you are found with anything remotely approaching CSAM, prison is going to be a rough space for you, but that's where you will end up. So this was it. It cannot happen again. Inadvertently, intentionally, law enforcement, probation, Department of Community Supervision is going to have the ability to look at your stuff when they think it's appropriate. And if they find something that is inconsistent with the conditions of your probation, we're going to be back together. Mr. Aurora will help you, but no number of doctors are going to be able to convince me that actually it's a whole lot worse than we thought. And you did a good job of masking what strikes me as inadvertence, maybe curiosity, likely inadvertence, as opposed to an illness that we need to protect people from. You understand, Mr. LaChapelle, that you're required to register as a sex offender as part of this plea.
Yes, Your Honor.
And that will place limitations on the type of work you can do. Your current job should be A-OK, but you could never work in a school or an amusement park or any job that would expose you regularly to minors. You understand that?
Yes.
It also will place limitations on where you can live. I don't know that people have run a check of your parents' address or your grandparents' address, but you're going to need to navigate that. Those households can't be too close to parks or schools because of the conditions of having to register. You understand that?
Yes, Your Honor.
Okay. Mr. Aurora, one thing we didn't talk about that came up in the Highland report a number of times and is one of their recommendations is substance abuse. Tell me your concerns, if any, about that. I don't want to leave that unaddressed. If that's a possible gateway to, I already have fewer inhibitions, I meaning Mr. LaChapelle, than other people, and then if I'm drinking or smoking something, I have even fewer, or I'm more curious, and I don't have a check in place that would remind me, I better not go to this website because I'm going to prison if I go to this website.
I know he had a alcohol possession or DUI like that years ago in Cobb County, which we shared with them. I'm not sure about the details he can answer, but I've not had any issues with him drinking or any type of drugs or any of that type of stuff.
Okay.
And unless you're aware of anything, Mr. LaChapelle, this is Mr. LaChapelle Senior, just for the record.
Got it.
I don't think it's a problem, but I think they mention everything because it takes 3 days to go through all this testing, sometimes more.
Okay.
In our case, it took a little while longer because of the communication, understanding what questions mean.
Well, they were thorough, and I just want to make sure we don't leave that unaddressed. But it sounds like, Mr. LaChapelle, you don't think you struggle with any illicit substance use.
No, I do not. I've quit drinking for 3 years in one instance with no problem. I don't use any drugs. I don't like Advil unless I really, really have to. I'll take it. I just know it does long-term damage to my body, and I don't like that kind of effect.
Okay, you sound like our Secretary of Health and Human Services. I think Advil is okay, so is aspirin, but you are not prohibited from taking a medication that you can buy in a grocery store, and certainly not prohibited from taking a medication that's prescribed by a doctor. I just want to make sure you aren't self-medicating in other.
No, I was not.
Okay, all right. Well, that is helpful to know. Mr. LaChapelle, I'm going to sentence you on each of the 15 counts to 10 years to serve on probation, followed by 10 years suspended. So there are 20-year terms. The first 10 are active, meaning you will be supervised. If you do well, you may be moved to unsupervised probation. That's really up to you and how well things go on probation. But at that 10-year mark, if you haven't been removed from probation, you definitely will be. And you're still under sentence, but you don't have any reporting requirements. You'll still, whatever the registry says you need to do, you'll need to do that. But it is a suspended sentence. I need to explain to you what that means. The one condition that I'm putting in place for your suspended sentence, back 10 years, is that you obey the laws of Georgia, the other 49 states, and the United States. So you don't have a probation officer, but if in year 12 you get arrested and there's something on your computer that shouldn't have been there, the state can come to me saying, whoop, he violated his suspended sentence. And just like I can revoke probation, I could revoke the suspended sentence and turn it into custodial time. Do you understand that?
Yes, Your Honor.
Okay. You'll be required to register. You've already signed all that paperwork. They're fairly onerous requirements. You may seek relief from those at some point. You need to do that with a lawyer's assistance. But while you're under sentence, it's pretty hard to get relief from the registration requirements, with the possible exception of maybe a residency exception. If you've been living somewhere and it happens to be 980 feet from a park, I'm happy to get involved saying, I don't think Mr. LaChapelle needs to move, but it's not 100% my call, okay?
Thank you, Your Honor.
I'm going to impose a $1,000 fine that is payable in the first 6 months of probation. And you need to understand, I don't know if you have nephews or nieces, but one of the conditions is that you not have contact with minors. And that gets complicated if you're having a family get together and there's a 10-year-old niece who is going to be around. You discussed that with your family and Mr. Aurora?
Yes, Your Honor, we were going to ask if he could be supervised when the family's around so he can attend some of these things, because obviously it's very important, but otherwise there's no need to be one-on-one with minors.
So you can have supervised contact with minors who are relatives. So if you're at a family event and there's another adult in the room, in the car, wherever you're traveling, that's okay. But those minors need to be immediate family members. So nephews, nieces, cousins. It's not you get on a bus and decide you're going to sit next to 3 kids in the back of the bus who are strangers. Understand?
Yes, Your Honor.
Okay. I've shared a lot with you. Do you feel like you followed what I've had to say?
Yes, Your Honor.
Any questions about any of that?
No, Your Honor.
Mr. Bridges, the conditions that are imposed because this is an offense that requires Mr. LaChapelle to register are pretty thorough. I'm not articulating them out loud. They're in writing. I've signed them. Mr. LaChapelle has signed them. They're binding on him. Are there any conditions that you wanted to see as part of his sentence that are not part of either what I've said or what are in the roster of conditions for a sex offender?
Just one, Your Honor, where he's located at, as far as housing, ask that house on their internet has a filter on it. Basically, that filter will now allow certain material to come to that computer, just in case. Because one of the things I heard consistently that this wasn't something that he maybe planned or thought of, it was spontaneous due to this condition. If he actually has a back opportunity to see something, the filter would actually filter it out. And most internet provider has this filter on the system.
Okay, I understand your request, and I'm open to imposing a condition like that. It needs to be something that would allow other family members to do what they want online, that's legal, so that they wouldn't be unable to watch a movie that might run afoul of a filter that would be something Mr. LaChapelle shouldn't watch.
Most of those filters have a level on it that you can set, and so set the level to actually exclude those type of materials.
Ms. Simpson, do you know if that's something that probation works with as part of the sex offender conditions?
Our specialized cases division, they have either a device where they use a specified software that tracks if a supervisee goes to any formal website that's not supposed to be on.
Okay.
So they're automatic, that also is automatic.
Okay, and that's on the devices in the household?
Yeah.
Okay. Mr. Aurora, your thoughts about it? I think it makes sense. I want to be mindful of Mr. LaChapelle's family's privacy interests.
Usually, even in federal court, when we've done it, it's been whatever devices the individual has. He identifies those to probation and just loaded on his material, because otherwise, if you put it through the whole house, I've not experienced that before.
Right, but how do we manage, hey, my mom's not home, I'm gonna hop on her laptop because it doesn't have a filter on it?
I can say, they all have passwords and I do not know the passwords. Or if I did, like I'm taking the Italian class, my goal is to get my Italian citizenship and eventually move there and work there. I've always asked my parents permission and they've been right there, and I just use Google for a translator and that's it.
Okay. All right, we'll try it out and see how it goes, the approach that Department of Community Supervision will use. Mr. LaChapelle, I'm excited that you are learning Italian. I do want to manage your expectations that while you're under sentence, you would not be allowed to move overseas.
I understand that.
Okay, so you'll be a little older before Milan or Florence is ready for you, okay? All right. Ms. Simpson, is there anything else I needed to cover from DCS side?
Judge, I have given reporting instructions to his father. He would not be reporting to us in person. One of our officers will be going to him to the person.
Okay. Mr. Aurora, one last question I can think of. Your client's father indicated that he may be staying some with his grandparents. I guess we just need to be thoughtful about what the residence is. I don't have an issue with either, assuming they're both compliant with the registry requirements, but Department of Community Supervision doesn't need to be guessing where he's going to be.
He's going to be at his parents' house, except for when support is needed to take care of his grandmother. So if something happens, he can drive her somewhere.
Got it.
They need somebody with them in the evenings on occasion.
Okay.
When the father-in-law isn't there. And so we'll work all that out because he's been given a gift and his father and his family appreciate that from this court. So nobody's going to screw it up. Everything's been password protected for the last 2+ years.
Okay.
And so they don't want to go through all this and have him end up back here. So everybody's got a vested interest on his behalf. So he's very lucky to have that.
Okay, he is.
Prior is.
Of course, we'll leave messages. I know it's impossible to reach anybody at probation, but if we get an email, we can let them know. Okay. If whatever number you give him, if he's going there, he will just text them from his flip
No,
phone.
he needs to give them a heads up before he goes.
Right, that's what I'm saying. He will text them before he goes to his grandparents' house.
Not the day of, right?
Well, they'll work through this. If he's not doing it the right way, probation will explain, and if probation is having to reach out to me, then we're having problems early on. So emergencies come up. I don't want to say you couldn't go to your grandparents at a moment's notice, but the more it can be a routine, you know that on Tuesdays, you're going to be there at 6, the more comfortable probation will be. Especially early on, they're going to get to know you and they want to get a sense that you're going to be a reliable partner in the process. Okay?
Yes, Your Honor.
Okay. All right. Thank you, everyone.
Thank you.
Mr. Bridges, thank you for your time. You don't have the other one. Ms. Winfrey has Mr. Aurora's other case, and that we'll just deal with on the call of the calendar.
I'm hoping to do it earlier, but I haven't been able to reach her. I've emailed her and texted her, but I'll figure it out. I was hoping to do it before that.
Okay. Does that have similar intricacies as this,
I'm
or?
not going to be as sympathetic for the other one.
Okay. Well, all right. Thank you, everyone.
The best way I can say it.
Okay.
You'll need to sign up with probation, so just hold on. He's got it.
Ms. Shelton, have you had a chance to speak to your client? And what are we doing today?
Mr. Washington?
We would like an evidentiary hearing.
Okay.
So I know that that means that my client will be released today, and I'm not sure, we can't, we'll get the date this week.
We'll figure it out. I mean, we'll talk about it. I will just want Mr. Rakestraw to be out here for that. So what I'll do is bring him to the door and explain that you're asking on his behalf for an evidentiary hearing. Then I'll work with Ms. Nelson, my litigation manager, to figure out how soon we can do that. Do you have a sense, Ms. Smith, is this going to be your case? Is it just getting an officer, or is it 6 officers from far, far away? Sometimes well, let me look at his.
This is a Fulton County case.
Okay.
It's about 2 to 3 officers we're gonna be sending out subpoenas for.
Okay, so it's an afternoon or a morning?
Yes.
Okay. And it's not yet indicted?
No, it's still a PI.
Okay. All right, yes, just Mr. Rakestraw to the door, please. And then what are we doing with Mr. Harris?
Plea.
A plea. Yay, it's been worth it for Decatur County. They've been.
Thank you, Jeff. I'll see you in a few weeks.
You bet. Take care. Nice work. Hey, Mr. Rakestraw, I'm Judge McBurney, and I was chatting with your lawyer, Ms. Shelton. She explained to me that her hope for how this revocation would go is different from what the state was looking at. And because there's a divide between what the state's recommendation would be and Ms. Shelton's, you and your lawyer are exercising your right to have the state prove it up. It's their burden. So we're going to set this down for a chunk of a morning or an afternoon coming up soon. The state has the burden of proving that you in fact committed this burglary in the 2nd degree in November of last year. The burden of proof is lower than a trial, but they still have to prove it. And so they need to bring in officers. You'll be here for it. Your lawyer will be able to cross-examine witnesses, and she could call witnesses if there are witnesses she wants to present on your behalf. And then I'll let you know what we're doing. If the state met its burden, then I'll find that you violated your probation and I'll tell you what the consequences are. If the state didn't meet its burden, then I'll dismiss this. And if there's nothing else holding you, then you'll be released. Does that make sense? Okay. So we will see you soon. Ms. Shelton, will it be you? I know you're with Mr. Barber, but you are counsel of record for Mr. Rakestraw? Great. Okay. Then we'll reach out to you and Ms. Smith and lock in that date for the hearing.
Thank you.
Okay. Any questions, Mr. Rakestraw? Okay. All right. See you soon.
Your Honor, that concludes my business.
Yes, thanks for your patience.
Thank you.
Thank you, Judge.
You're welcome. You're welcome. So we've got Harris, Bradford. Did you end up talking to Mr. Bradford?
Yes, Judge, that'll be just really quick.
Okay, just a waiver?
Yes, Judge.
Okay. And Mr. Hardison left. Did you guys talk?
We're in the midst of talking, Judge.
Okay. And then any update from Ms. Gordon?
Oh, no, let me text her, Judge.
Okay.
You want to bring back some of the, okay.
Judge, is Ms. Gordon on the call? She asked for the Zoom information.
Good question. Nope, I don't see her unless she's using an alias. Hey, Mr. Bradford. Good morning. I'm Judge, it's afternoon now. Good afternoon, Mr. Bradford. I'm Judge McBurney, and your lawyer, Ms. Wood, told me that she had a chance to talk with you, and she's going to waive arraignment on your behalf, so entering a plea of not guilty.
First of all,
Don't talk about the facts of the case.
I have to.
No, you don't have to. I'm going to let you speak in just a minute, but let me just tell you what's happening, and I'll hear you. Your lawyer may tell you to stop, but you're the boss of you. All we were doing today was figuring out, does Mr. Bradford waive arraignment, as in he's entering a plea of not guilty, and we move forward? Or does he want to be formally arraigned, which means I read into the record the charges, burglary in the second degree and criminal trespass, and advise you of your rights that you're already aware of. 99 times out of 100, lawyers waive arraignment on behalf of their clients. You're not being shortchanged in any way. I'll be issuing a scheduling order, and the prosecutor, Ms. Smith, will be getting discovery to your lawyer so she can see what the state has or doesn't have. And then Ms. Wood will be talking with you about the best way to move forward based on the strengths and weaknesses of the state's case. So that's all a waiver means, is that we can get your case moving forward. What did you want to say?
I'm trying to find out, did anybody do the investigate and find out where I was? Because I'm being told unlawfully, I was locked up.
Okay, so that's something that Ms. Wood can do. If you tell her where you were locked up.
I've been told to 3 other lawyers that I had.
Well, Ms. Wood hasn't told you that and not done it. Someone else may, and I'm not vouching for them. But Ms. Wood is the lawyer who will have your case until your case is resolved, whether it's dismissed because they got the wrong guy and there's an impossibility of proof, or it's a plea, or who knows what. I'm pulling up the indictment right now just so we're talking about the same situation. The allegation in the indictment is that you did something on, forever ago. December 23rd, 2017. So Ms. Wood will be poking around the records to see, unless you were in jail at the Life Church, which is where this supposedly happened. Okay, all right, Ms. Wood.
Yes, Judge. So I did file a speedy trial demand this morning
Oh.
on his behalf. He gave me some new information when I spoke with him. We're gonna investigate that. Maybe a notice of alibi is coming down, but
Okay.
I'm on it, Mr. Bradford.
Got it. Yeah, and let me tell you, Mr. Bradford, a speedy trial demand, that is a sign that Ms. Wood is shifting into overdrive on the case.
She put in for a dismissal and it's not being,
Well, I'm not aware of a motion to, a motion to dismiss for statute of limitations. What an interesting case. All right.
There's more to, yes,
At
Judge.
the same time, I was on probation. My blood was in the database for federal and for state.
You were a busy guy back then.
And I'm living in the state of Georgia.
Okay. All right. A lot of moving parts here. Ms. Wood is on it, and she has papered your file well. I see the speedy trial demand. I see the motion to dismiss for a violation of the statute of limitations. About violation, but it may be that the state came too late in bringing this indictment. We'll figure it out.
The state made me lose everything. I lost a wife, I lost my house, I lost my job and everything.
Okay.
Nobody is gonna compliment me for nothing like this, okay?
Well, when you get out,
You go to see my own wife,
when you get out, you'll be able to explore whether there are remedies if you think there was a wrongful prosecution. Okay? All right. I will see you soon.
Thank you, Judge.
Thank you, Ms. Wood.
next time I'll be in court.
I need to read through all of Ms. Wood's filings and we'll figure that out. Okay? Because I want to hear about the statute of limitations thing.
That question is probably gonna be moot based on some information from the senior center.
Okay, I just was trying to
Sure.
get him where he needed to be, but the Speedy goes on our radar.
He just had a revocation.
It's Floyd.
Yeah, he was revoked to, PC.
Oh, okay.
So, he's finished here, this,
Got it.
Well, maybe we'll finish here soon. All right, yeah, just doing the math, that would get us to 2022, not 2025.
We talked to.
I'm sure there's always more to it.
Yeah.
You would have, if you saw it otherwise, you would have done something about it, and you're good. All right, so I think we're going to do a plea now with Mr. Harris.
Yes, Judge.
Okay, if I say that the prosecutor was able for the plea, it was like.
As long as you move the microphone towards you, so that Ms. Rivers can hear you, I'm good. You can, oh, because you're right, he doesn't need to be twisting his head around, so that's great. Okay. Mr. Harris, can you hear me?
Yes, I can hear you.
Great. You must be, have you been sitting in that chair the whole time, or did they let you get up and move around a little bit?
No,
No, you have not been able to get up and move around.
no.
Okay, well, let's knock this out then. Ms. Wood told me that when the two of you spoke in private, you've decided to enter a plea in your case. Is that correct?
Yes, sir.
Okay. The way that is going to work is in just a moment, Ms. Smith, who you can see on the screen right there, is going to put you under oath, and she will then ask you a bunch of questions about your case. You need to answer those truthfully and completely. I'll hear from you, I'll hear from Ms. Wood, and assuming I accept your plea, we'll get you out of that chair, okay?
Yes, sir.
I need you to tell me a couple things before I let Ms. Smith take over. First, Mr. Harris, you are appearing from Decatur County Correctional Institute and not here in my courtroom. Are you waiving your right to be physically present in court?
Yes, sir.
Second, Ms. Wood is here. She is not. Where is Decatur County? How far is that from Atlanta?
3.5 hours.
Okay, it's far away. Ms. Wood is not there. She's here. Do you waive your right to have your lawyer directly by your side?
Yes, sir.
Okay, if you need to speak with her in private, let me know, and I'll get you guys in one of those breakout rooms again. Finally, let me know if at any point you cannot hear us or you've got a question about something someone said. Will you do that?
Yes, sir.
Thanks. All right, Ms. Smith.
Mr. Harris, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before the court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Keith LaShawn Harris, Jr.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
And is there any medication that you would normally take that you haven't been given this morning?
No, ma'am.
How old are you and how far have you gone in school?
I'm 25 and I got to 9th grade and got locked up.
You said in 9th grade you got locked up?
Yes, ma'am. Yes, sir.
Okay.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, ma'am.
Do you need more time to discuss your case with your attorney?
No, ma'am.
And are you satisfied with her services?
Yes, ma'am.
Counsel, are you satisfied your client has a full understanding of this proceeding?
I am.
Do you also waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
We do.
Mr. Harris, do you remember being arrested on these charges?
Yes, sir. Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
No,
We are
ma'am.
not.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 2 years to serve?
Yes, ma'am.
Are you aware that the court does not have to accept that recommendation and that the court can sentence you to the maximum on each charge and can run those sentences consecutively?
Yes, ma'am.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes, ma'am.
Are you currently on probation?
Yes, for call.
Do you understand that since you're currently on probation, you may be revoked based on you entering this guilty plea today?
I was finna say the time which I was finna give me now, this is the time what I'm down here doing for. Call gave me
Not
the
on probation.
time for that.
Okay. All right, got it.
Can we clear that up? I don't want Mr. Harris to be confused. What he's pleading to now would not be a basis to revoke any probation?
He won't actually go on probation until next year when he gets out.
For his Cobb case?
Yes, sir.
Got it. Okay, so you're pleading today in a case from September of 2024. We'll talk more about the facts in a minute, but this plea will not be a basis to tangle with, mess up your Cobb County probation. You understand that?
Yes, sir.
Okay.
All right. Mr. Harris, are you a United States citizen?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, your right to hold public office, the right to serve on a jury, the right to obtain a passport, or your ability to obtain employment.
Yes, ma'am.
Do you also understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you could be charged with another felony offense?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this guilty plea today?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Counsel, are you satisfied your client understands that these are the rights they'll be waiving by entering this guilty plea?
I am.
Okay. Mr. Harris, has anyone forced, threatened, or promised you anything for you to enter into this guilty plea today?
No, ma'am.
As to indictment number 25SC006544, how do you plead to count 1, theft by receiving stolen property, and count 2, driving, fleeing, or attempting to elude a police officer?
Yes.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Can you repeat it?
Yes. Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you do not have a right to appeal directly from your guilty plea, but if you believe that there is some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal?
Yes, ma'am.
Do you also understand that that has to be done within 30 days from today?
Yes, ma'am.
Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
All right. Thank you, Mr. Harris. Your Honor, if this case were to proceed to trial, the state would show that on September 16th, 2024, Officer J. Lyons, Lyons, of the South Fulton Police Department responded to a flock hit for a stolen vehicle on Martin Luther King Jr. Drive. The defendant, Keithier Harris, was the one that was driving this flock hit. The vehicle for the flock hit, which was a Jeep Renegade that was reported stolen from Tawana Winthall. The vehicle was seen getting onto Interstate 20 east from Six Flags. The officer noticed that the vehicle was traveling about 90 to 100 miles per hour, and the officer activated his emergency lights to pull over the car. When he tried to pull over the vehicle, Mr. Harris then started to increase his speed and did not stop for the officer. The vehicle eventually took the H.E. Holmes exit and drove into an apartment complex, which at that time the defendant fled the vehicle and started to run on foot. The officers caught up with the defendant, and the defendant fell to the ground, at which time he was detained by the officers. When the officers advised the defendant that the vehicle was stolen, he stated that he rented the vehicle from someone else that morning, but did not provide any further details. The defendant then told the officer that he ran because he was on probation and his driver's license was suspended. All of this occurred in Fulton County, Your Honor, and those are the facts of the case. Regarding the negotiated plea between the state and defense, we've agreed to a sentence of, for count 1, 2 years to serve, and for count 2, 2 years to serve, for that count to run concurrent with count 1. And for this indictment altogether to run concurrent, bless you, to the current sentence that Mr. Harris is serving in DOC. And that is all from the state, Your Honor.
Thank you. Ms. Washington, can you share criminal history information, please?
Yes, Your Honor. There are 5 arrest cycles, a 2023 felony conviction for possession of a firearm by out of Cobb County, a 2019 felony conviction for 2 counts of armed robbery, theft by receiving stolen property, 2 counts of possession of a firearm during aggravated assault and hijacking a motor vehicle, and that was out of Cobb County. Nothing further.
Thank you. So, Ms. Wood, I'm trying to track Mr. Harris's whereabouts. He bonded out on this, but he says he's been in jail a whole lot. Tell me what you understand happened after he bonded out here.
Sure, Your Honor, because it looks like so yes, he was originally he was in for 10 days and then he was released. It appeared he was released not like to the streets, didn't have a hold at that time. And then I don't know, perhaps he was in Cobb at some point in between there because he was taken back into custody here in July of last year. And he did 3 days from July 6th to July the 8th. And then he was transferred from here to Cobb County and did a couple of months there. And then he went directly to Jackson on September 11th of last year.
Okay, so July 6th or 5th of last year, he went in. He's not been out since then.
That's correct.
And whatever happened in Cobb resulted in the 2-year revocation.
Yes, and they did revoke him based on these charges. And so his current max out date is August 13th of 2027.
Okay.
And so we're just asking that you accept the state's recommendation in this case. And it should be pretty easy for the Department of Corrections to calculate that time since he's already there.
Right. Mr. Harris, one of the convictions that pretrial services mentioned was an armed robbery conviction. Those are usually 10 years to serve. What happened with that? That was your 2019 case. Was it reduced, or what did you end up?
It was reduced. It was reduced to armed robbery down departure and hijacking motor vehicle down departure.
To what?
I don't know what it means.
Downward departure. Got it. Okay, I understand. So the prosecutor agreed to let you be sentenced below the 10-year mandatory minimum. How long did you serve for that case?
5 years straight.
Okay. So that got,
5.
okay, and that got you out, what, in like 23, 24?
No, I actually caught the case in 2016 and got
Oh.
sentenced in 2019 and got out in 2021 at the end of
Okay.
2021.
You stayed in from 2016, which I guess would have been when you were a 9th grader.
Yes.
Okay, got it. And was that a Cobb County case?
Yes, sir.
Okay. The pieces have come together. Do you have any questions, Mr. Harris, about what we've been discussing?
No, not for real.
Okay. Well, Mr. Harris, I find there's a factual basis for your plea. Back in September of 24, you were driving a stolen car and you did not want to get caught. So you drove fast, fled on foot, etc. I also find that your plea is knowing and voluntary, meaning you've understood what we've been discussing and no one's forcing you to enter this plea. You agree with that?
Yes, sir.
Okay. Ms. Wood, can someone in my office sign the indictment for you?
Yes, Judge.
Ms. Smith, can we sign for you?
Yes, Your Honor.
And Mr. Harris, is it okay if we electronically sign your name indicating your guilty plea to theft by receiving and fleeing and attempting to elude?
Yes, sir. You can sign it.
We'll do it. All right. I'm going to sentence you to 2 years to serve on both counts. I will run those concurrently and run your sentence concurrently with the sentence you've been serving since you were arrested in July of 2025. Okay?
Yes, sir. Thank you.
You're welcome. I hope when you get out, you're ready for something different. You have not had a real exciting and uplifting last 5-6 years.
At all.
Do you have family around that you can be with when you get out?
Right now, I'm down here working on my GED because they gave me a modified sentence on my case. And my judge, she say, once I complete my GED and stuff, like she'll terminate the 2 years of what she gave me.
Okay. Who's your judge?
I forgot.
Some judge. Okay. Well, what's important is what she said, not who she is. I hope that works out for you. GED is probably a good step forward. If you don't have any other questions, Mr. Harris, I appreciate your patience and I very much appreciate the good folks at Decatur County CI for leaving this channel open for so long. You're good to go.
Thank you.
All right. Bye-bye. Thank you, Decatur.
Thank you very much.
You're welcome. Good luck to you, Mr. Harris.
Okay.
All right. I think that covered everything except for, Mr. Hardison, who's here, and then Cameron Wright, but we'll work through, I'll reach out to Ms. Gordon.
And I just got a text from her. She's in the middle of a murder plea in Judge Krause's courtroom, so.
She should be there.
Yes.
So we'll reschedule Mr. Wright. What are we doing with Mr. Hardison? So was this a PTI opportunity for him that kind of fell apart?
Yes.
So I'll start with you, Ms. Wood.
Your Honor, so I did speak with Ms. Smith. Mr. Hardison's concerns about the recommended increase of community service hours is because he works 2 jobs currently. And so he had proposed maybe doing less community service hours in addition to a fine. We did a little back and forth with that. And I think now he is a little frustrated and wondering why, basically. He can't just do a fine in lieu of community service.
So, hold on, let me mute. I don't know why that was, there we go. Mr. Hardison, way back when you were given what struck me as a pretty reasonable opportunity to check some boxes by doing some community service, things like that, and your case goes away. What Ms. Smith discovered when she did a little digging was that, at least from the materials she shared with me and Ms. Wood, that you might not have been all that forthright about how you did, where you did, and how much you did for community service. Given the state's perspective on that, I can understand why they'd say, first of all, they could say, forget it. No more pretrial intervention. Let's move forward. If he wants to plead, he can plead. If he wants to go to trial, bring it. We'll get a jury in here and we see what happens. They had that right because you kind of reneged on the pretrial intervention. They also have the ability to say, all right, we'll give you a second chance, but because of how you treated the first chance, we're going to turn up the heat a little bit and you're going to need to do something more, whether it's more hours or hours plus fine. You don't really get to dictate those terms, but you also get to say, no, I'm like, no, thanks. Let's just move forward with the case. I'm neutral. If you do the pretrial intervention and this time actually do it and can document it and don't play games, the state will dismiss your case. All right, case closed. If you don't want to do it, and I respect that, you're busy, you got multiple jobs, but the state's saying fine isn't going to do it, then you can say no thanks, and then we'll just get you back on track to have a trial. That doesn't mean you have to have a trial, but it means either then you're going to plead or we do a trial. So you need to figure out what is the best fit for you. And you may want to talk to Ms. Wood a little bit more about it, but no one's leaving today till I know what the next step is for your case. It's an older case now, 2024. Here we are in 2026. And I need to know, should I set a deadline a few months out? You'll take care of pretrial intervention, or should we get this back on track, final plea and trial date? So any questions about what I said? You feel like you understand it? Do you know what you want to do, or you want to talk with Ms. Wood? Okay, why don't you do that?
We can put it back on our draw calendars.
Okay, let me check the docket to see where. All right, so we already had final plea, so we'll just put this on the next available trial calendar, which will probably be April. My guess is March has already been filled out. I don't want to misrepresent that there's room on that. You will get notice of when you need to be here. Ms. Wood will be reaching out to you anyway. You still at Buffalo Court? No, all right. You need to fill out a change of address form before you go so that we can update your address in the system, so you do get something in the mail. Because if you miss court, but we sent it to an address you didn't update, that's on you. Like I said, if you go to Ms. Simpson, she's got the form. You can get that new address in there. And we'll add it to a trial calendar. You're welcome. All right, before you guys go, and I know it's been a long morning, but we don't have any purple this afternoon. Tomorrow is going to be a complicated day. Morning is fine, but the afternoon, I have to testify in front of the Senate about the Council of Accountability Court's budget, and they've given me a window, so I'll be away some. Are there things in the afternoon? I don't know, for example, who has Laura Charles's case.
I do.
Is that something we could do in the morning, or she needed it to be in the afternoon?
We can do it in the morning.
Okay, my request was, I'm going to talk with Ms. Nelson about what's on the plea and arraignment. If there are things that we could have people show up in the morning. They won't get a bench warrant if they don't show in the morning because the calendar is for the afternoon. But the more we can fit into the morning, the less people will be stuck. I'm not going to be gone all that long, but I don't control the agenda. It's a bunch of different agencies. We asked to be towards the end so people can go first, and then I'll just pop over there. But that's a little hiccup tomorrow afternoon. Okay, sorry about that. I think that's it. Anything else from you, Ms. Smith?
No, Your Honor.
No? All right, thanks for all your hard work. Ms. Wood, anything?
No, Judge, thank you.
All right. You guys wish that my cold goes away.
Yeah, feel better soon.
Oh, it's the worst.
It's the weather.